Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen. Amen. Namaste.
Oath or affirmation, announcements by the Speaker.
Honorable members, I have received communication from Ms. Sharianne Critchlow-Coburn, MP, Member for Lupino, Bonia West, Mr. Boendradat Tiwari, MP, Member for Caroni Central, Mr. Prakash Ramadar, MP, Member for St. Augustine, who have requested leave of absence from today's sitting, and from Mr. Barry Padarath, MP, Member for Prince's Tongue, who has asked for leave of absence for the period May 29, 2020 to June 30th, 2020. The leave which the members seek is granted.
Bills brought from the Senate, petitions, papers.
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, I have the honor to lay the following papers. The ministerial response of the Ministry of Education to the 13th report of the Joint Select Committee on State Enterprises on an inquiry into the operations of the MIC Institute of Technology with specific reference to the high dropout and failure rate of its trainees. Paper number 2. The ministerial response of the Ministry of Education to the 21st report of the Public Administration and Appropriations Committee on an inquiry into the oversight of state agencies under the purview of the Ministry of Education and funding to private secondary school institutions. Paper number 3. The ministerial response of the Ministry of Education to the 13th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the prevalence of teenage pregnancy and the state's capacity to minimize the occurrence of teenage pregnancy and provide services and assistance to teenage parents. Thank you very kindly, Madam Speaker.
Reports from committees.
The member for Tunapuna.
Madam Speaker, I have the honor to present paper number 1, the 4th interim report of the Joint Select Committee appointed to consider and report on the miscellaneous provisions Local Government Reform Bill 2019 in the 5th session, 11th Parliament. Thank you, Madam Speaker.
The member for Rubuka, Maloney.
Madam Speaker, I have the honor to present the 2nd interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018 in the 5th session, 11th Parliament.
Prime Minister's questions, urgent questions.
The member for Couva South.
Thank you very much, Madam Speaker. Madam Speaker, to the Minister of Education, given that students will be required to write the Caribbean Advanced Proficiency Examinations, CAPE, and the Caribbean Secondary Education Certificate, CSEC, examinations in July of 2020, could the Minister inform this House whether health and safety protocols for students, teachers, examiners, invigilators, supervisors, and other employees involved in the examination machinery have been finalized?
The Minister of Education.
Thank you very much, Madam Speaker. I am pleased to state that the very simple answer to this question is yes. These protocols, these safety protocols for students, teachers, examiners, invigilators, supervisors, and other employees involved in this examination, these protocols have been finalized with the Ministry of Health. Thank you.
Supplemental, member for Couva South.
Thank you very much, Madam Speaker. Minister, could you inform this House in relation to the question posed being in the affirmative, whether the safety protocols have had the agreement of stakeholders such as the Trinidad and Tobago Unified Teachers Association, the Principal Secondary Schools Association, and also the National Parent Teachers Association?
Minister of Education.
Thank you once again, Madam Speaker. Yes, we have been in constant dialogue with all our stakeholders. And in fact, if I had with me, I would have shown you a paper that we got from the Association of Principals of Public Secondary Schools, in which these protocols were written to ensure that all our teachers, our students, all our stakeholders are fully aware of the necessity to abide by these protocols. So again, my answer to the member from Couva South is yes, we have had dialogue and consultation with all our stakeholders. Thank you.
Supplemental, member for Couva South.
Thank you very much, Madam Speaker. Minister, could you further assure all stakeholders and especially parents and teachers that thermal scanners and signage as it relates to social distancing and so on will all be in place in relation to the commencement of the examination?
Minister of Education.
Madam Speaker, the Ministry of Education is also working closely with the Ministry of Health to acquire thermal scanners for students, teachers, to ensure they don't have a temperature before entering the schools to write the exams. So again, I want to give to the member for Couva South the assurance that all these things will be put in place. Thank you very much.
Member for Chaguanas Peace.
Thank you very much, Madam Speaker. To the Minister of Education. In light of the recent publication by UWI's registrar that the university will relax its matriculation requirements, could the Minister state whether the Ministry and the Accreditation Council of Trinidad and Tobago were consulted on the relaxation of matriculation requirements at the St. Augustine campus for the academic year 2020-2021?
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, I have been in contact almost on a daily basis with Professor Brian Copeland, principal of the St. Augustine campus of the University of the West Indies, on this matter. And I've been assured that all these decisions that have been taken were taken by other arms of the University of the West Indies, not only the St. Augustine campus. In addition, I've been told that there was a meeting of heads of governments where these things were discussed. Now, the second part of the question with respect to let me make sure, the Accreditation Council of Trinidad and Tobago. Again, Professor Copeland has indicated to me that he has had discussions with Mr. Eduardo Ali, the newly appointed CEO of the ACTT, and he has assured him that discussions have been held and everything has been approved so that there is no problem with respect to the change in matriculation. Thank you very much.
Thank you very much, Madam Speaker. As the line minister responsible for UWI, could you state whether this relaxation of matriculation requirements, specifically at the St. Augustine campus, will affect the quality of education delivered at the campus?
Minister of Education.
Madam Speaker, there are two parts of this question again. First part is, he specified the University of the West Indies St. Augustine campus. In my response a while ago, I made it clear that the change in matriculation requirements does not pertain only to the St. Augustine campus of the University of the West Indies. The University of the West Indies now have 4 landed campuses and 1 open campus. And therefore, it will affect all four campuses and the open campus. In addition, let me state that the quality of education will not be compromised. Again, in discussing with the principal of the St. Augustine campus of the University of the West Indies, I have been assured that every effort will be made to ensure that our students receive the high-quality education that this university has been accustomed to delivering. So there is absolutely no question of the quality of education being compromised. Thank you.
Supplemental, Member for Chaguanas East.
Thank you very much, Madam Speaker. Honourable Minister, with respect again to this matter of the lowering of matriculation requirements, do you foresee that students will be required to take more remedial education to address any knowledge gaps?
I will not allow that as a supplemental question. Member for Chaguanas East.
Thank you very much, Madam Speaker. To the Minister of Finance, could the Minister state whether the government has given a directive/recommendation to the University of the West Indies University Grants Committee for campuses to cut their respective budgets by 10% or any other specified amount over the fiscal periods 2020, 2021, and 2021, 2022?
The Minister of Finance.
Thank you very much, Madam Speaker. No.
Supplemental, Member for Chaguanas East.
Thank you very much, Madam Speaker. In view of the response from the Honourable Minister of Finance, Minister of Finance, could you say whether in terms of the budget cuts that are expected, do you foresee any impact? And in terms, I'm going to come straight to the question. One of the reasons we have been told about the situation that we experience in the financial difficulty is the amount of receivables. Can you state, if you can tell us, how much money is owed to the University of the West Indies St. Augustine campus for gate contributions?
I will not allow that as a supplemental question.
Questions on notice, questions for oral answer.
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, there are 2 questions for oral answer, and we'll be answering both.
Member for Barataria Sanwa.
45 to the Minister of Public Administration.
The Minister of Public Administration.
On behalf of the Minister of Public Administration, Madam Speaker, I first need to advise the House that my responses to these questions are constrained or influenced by the following. The Government of the Republic of Trinidad and Tobago currently rents or leases approximately 350 properties throughout Trinidad and Tobago for the purpose of accommodating various state agencies. The records for these properties have traditionally been kept as hard copy files in the ministry's offices, making retrieval of data and effective management of the properties difficult. In 2016, the Ministry of Public Administration commenced the development of a computer-based property records management program known as the Property and Management Information System. This system contains files or records for the following categories of properties: privately owned properties offered for lease, private properties that have been offered for rental or lease, lease rentals, which are private properties that have been approved for rent or lease, and state-owned properties. Since the launch of this system in 2018, the Property and Real Estate Services Division of the Ministry of Public Administration has been digitizing its records, that is, scanning and uploading a digital copy of each document contained in the several files for each property under its purview. Both state-owned, approximately 1,200 properties, and privately owned properties offered for lease and leased, approximately 1,696 properties. To date, that division has digitized 544 of the 1,696 properties offered for lease and leased properties on file. Regrettably, because of the difficulty in retrieving the requested information from the files that have not yet been digitized, especially having regard to the constraints brought about as a result of the COVID-19 pandemic, the responses to the questions raised are restricted to the digitized records. Based on available information or records at the division, the number of government rentals that did not have the undermentioned approvals for the period 2005 to February 29, 2020 are as follows. Fire certificate approval, 126 properties. OSH approvals, 35 properties. Town and country approvals, 0. It is important to note that the approval of the Town and Country Planning Division is required prior to the rental of all private properties. As such, there are no instances of rentals without the Town and Country Planning Division's approval. Regarding the fire certificate and the OSH approval, these are always requested and obtained for all first-time leases or rentals and renewals. The duration of these arrangements is generally 3 years. Where rentals are continued or rolled over without a lease, that is, on a month-to-month basis immediately following the end of an approved lease or rent arrangement and pending a decision and action to renew, the fire service and OSH approvals would not be immediately acquired, therefore accounting for the numbers provided. Currently, the division is reviewing all government rentals with a view to ensuring that all leases are brought up to date and all statutory requirements are met. Given the number of properties for which approvals are not available, I am unable to provide an oral response to Part B, and as such, I request the permission of the House to submit a written listing, which I have on me. Thank you, Madam Speaker.
Member for Naparima.
Question number 68 to the Minister of Health.
The Minister of Health.
Madam Speaker, and I'm grateful for this question. Information received from the Central Statistical Office indicated that the total number of deaths recorded for the period January to March 2018 was 3,002, 3002. For the periods January to March 2019 and 2020, unedited data received by the Registrar General's Office, which collects that data, pending verification by the Central Statistical Office were, for 2019, 3,107, and for 2020, 3,052. Thank you very much, Madam Speaker.
Supplemental, Member for Naparima.
Indicate whether he has information for the month of April for these years.
Madam Speaker, the question posed was for January to March 2018, 2019, and 2020. I answered the question as posed. What I could say, contrary to what was said in this Parliament last week, where the Member of Parliament for Caroni Central, I believe, the Honorable Dr. Tim Gopi Singh, said, and I quote, "The Minister and the Ministry of Health and the government have to answer for the loss of lives of those people who did not receive treatment." These figures clearly show that the numbers 3002 for the period 2018, 3,107 for the period 2019, and 3,052 for 2020. The figure for 2020 actually went down. The number of deaths actually went down. So the untruth being put into the system last week that people are dying because of COVID is totally debunked by official figures. The official figure for January-March 2018, let me repeat, 3,002. 2019, it went down by 105. January to March 2020, 3,052, it went down again. Total number of deaths. But the UNC is putting out a narrative there that people are dying by the hundreds due to COVID, and the official figures absolutely put that conspiracy theory to rest. Thank you very much.
Member for Barataria Sanwan, supplemental.
Based on your death rates, 3,000 for the 18, 3,000 for 19, and 3,000 for 52, do you think it was necessary then to lock down a whole country and economic problems for 8 deaths in COVID?
Because
I will
if
not
we...
allow, Minister, please.
Oh, I would
I
love
will
to
not
answer.
allow that as a supplement.
Thank you very much, Madam Speaker.
Request for leave to move the adjournment of the House on definite matters of urgent public importance, statements by ministers, personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills second reading. Motions relating to the business or sittings of the House and moved by a minister.
Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, having regard to the 4th interim report of the Joint Select Committee appointed to consider and report on the miscellaneous provisions Local Government Reform Bill 2019, I beg to move that the committee be allowed an extension of 1 month in order to complete its work and submit a final report by June 30th, 2020.
Honourable members, the question is, be it resolved that the Joint Select Committee appointed to consider and report on the miscellaneous provisions Local Government Reform Bill 2019 be allowed an extension of 1 month in order to complete its work and submit a final report by June 30th, 2020. All in favor say aye. Aye. Any against? I think the ayes have it. Leader of the House.
Thank you, Madam Speaker. Madam Speaker, having regard to the 2nd interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018, I beg to move that the committee be allowed an extension of 3 months in order to complete its work and submit a final report by August 31st, 2020. Thank you, Madam Speaker.
Honourable members, the question is, be it resolved that the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018 be allowed an extension of 3 months in order to complete its work and submit a final report by August 31st, 2020. All in favor say aye. Aye. Any against? I think the ayes have it.
Public business, government business, bills second reading.
The Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Interception of Communication Act, Chapter 1508, be now read a second time. May I be reminded of the time in this House? Much obliged, Madam Speaker. Madam Speaker, we come together in this Parliament on a matter of deep and important public interest and concern. Whilst we fight the fight to save lives in a COVID pandemic, criminal activity still is intent on being a part of our society. Crime has gripped our country for decades, and many a government have come to the wheel of governance, the helm of that ship, and have not offered a comprehensive and connected methodology to crush crime. This government has been the exception to that rule. The exception to that rule has largely been premised upon a reformation of the criminal justice system in a most profound fashion. The reformation has involved treating with plant and machinery, people, processes, and law all at once. It makes no sense to have a law if you don't have a court to have it operational in, or to have a judge to hear it, or a prosecutor to prosecute, or a defense attorney. And whilst that record is one which we will treat with a little bit later, it is directly related to the bill before us. On the 3rd of March 2020, in the Senate, we had the third reading of this bill as amended in the Senate. And in that debate, we had the support of the independent bench. There were no votes against the bill on the independent bench. There were only 6 voices against this legislation sitting on the opposition bench. This law before us now is intended to amend the Interception of Communications Act, Chapter 1508. That is an act of Parliament that came to us in the early part of the UNC's tenure in 2010. On the 3rd of December 2010, it was passed. On the 17th of December 2010, it was assented to or proclaimed. On the 20th of December 2010, it was amended. That law brought into form and fashion, on the back of some scurrilous allegations, no doubt, a law which is designed to treat with the interception of communication over a telecommunications network. That is important to bear in mind, because whilst the Parent Act defines what communication is, and communication is quite properly defined to be all forms of communication in various iterations, the interception of communication is what is now an offense at law, and that interception of communication must be over a telecommunications network. That is to be found at Section 3 of the Act, where we deal, Section 5 of the Act, where we have the amendments contemplating the interpretation section, all holding on to what communication is. Madam President, Madam Speaker, this bill has a legitimate aim. The legitimate aim is to be found in very short measure across the following heads. Number one, we seek by these amendments to introduce the formal capture of a broader category of communication. That is, not only communication, which is voice, etc., over a telecoms network, but we treat with stored communication, and we treat with stored data. In doing that, we also move to another legitimate purpose, which is to introduce the concept of evidence being obtained from communications inside of a prison, and in the prison environment, also associated to that is the prison vehicles and prisoner depots. The third part of legitimate aim is in fixing the unconstitutionality of the 2010 law. The 2010 law, even though it was passed with a 3/5 majority, is an ouster of the court's discretion. It breaches the separation of powers principle because the admissibility of evidence, particularly in section 17 and 19 of the Act, is deemed to be shall admitted. Evidence shall be admitted with no discretion to the court. The legitimate aim flows further in adding the modern use of technology alongside the modern aspect of criminality. Where criminality uses technology, the balance of rights of the individual, whether those rights are in due process of law, section 4.1a of the Constitution, whether it is in protection of the law, 4.1b, whether it is in the right to private and family life, 4.1c, or the right to fair trial in 4.1b, those individual rights fall against the public right that is enshrined in our Constitution as well, in particular the first right enshrined, and that is to life and liberty of the general citizens. When we look at the balance of technology as it is used by criminality, when we looked at the data in Trinidad and Tobago to see that there is a rampant cell phone usage in our prisons and in places of detention where literally murders are being called for on communication devices from in the prisons, whilst the existing law in section 6.2 allows for the interception of communication for national security purposes, etc., the evidence of communication cannot find its way into court unless it is by way of warrant. Put quite simply, you may have golden evidence which you can't capture again, where a killer calls for a shot from a prison. You miss that opportunity and you can't convict the person because the evidence is not there. Whilst the common law allows for, in the case of R.V. Strange in particular, for a disregard of the manner in which you capture evidence, i.e. it is not in the face of an absence of statutory prescription, it is not something which a court looks at as to how you got evidence. The fact is that the common law allows for evidence to be admitted even though it was admitted in unlawful conditions where there was no statutory provision. The other aspect of what we treat to in this legitimate aim is in providing the court's discretion and in adding the court's discretion for all matters that come up of evidence. Be they evidence under a warrant in section 8, a warrant in section 11, the admissibility of evidence in section 17, the admissibility of evidence in section 19. We have to cure a serious illegality, a serious unconstitutionality in the existing law by making all evidence, even if it is sensitive evidence that can reveal the identity of a person, the manner in which the intercept was done, we have to allow the court to consider that. And therefore, one of the high principles in proportionality in this law is that we now allow the court and only the court to be the arbiter as to the admissibility of evidence. The measures proposed in the bill to treat with it are rationally connected to the legitimate aim. The measures are the least intrusive measures as a matter of law because they comply with what we know in the common law already. Those least intrusive measures include the fact that a judge supervises the admissibility of evidence. Those least intrusive measures also include the fact that there are specific safeguards built into the legislation proposed in this bill, where we include what is referred to as the Bailey principles, so that you have interception or you have what we call bugging, you're recording conversations in a prison, that they must be proportionate in the manner in which the bugging is done. So if it is always to be determined, it must be determined under the lens of the interest of justice. That means it's the least intrusive. In looking at the further proportionality, we're also looking at the proportionate effect. Does it help to balance the country's interests in a society such as Trinidad and Tobago that we actually take these measures into effect? So, Madam Speaker, permit me now to dive into the bill. Because the constitutionality of the bill is a very important point. It is definitely the case that this law is constitutional, whether we use a majority support for it or not, but we have brought it nonetheless with a special majority consideration. And we have, as I've said in the Senate already, we have many options available in considering how we refine the law, how we consider the law, and how we pass this law, because the society is crying for justice as we speak. Madam President, Madam Speaker, let's jump to Clause 5. Clause 5 adds definitions. We looked at the definition of an address. An address includes a telephone number, electronic location, or physical location. Why? Because part of this law is to also allow what we call triangulation. It is to allow traffic data to be captured so that when the police are looking for somebody at a location in a live intercept, the traffic data can pinpoint you by way of cell tower triangulation. We see it in the movies. If it's good enough for the United States movie audience or the Bollywood movie audience, then it surely is good enough for Trinidad and Tobago. When we get to the definition of communication data, here is a critical point. Traffic data, information, these aspects of communication data, coupled with the new definition we propose to introduce to stored data, this allows for the Interception of Communication Act to allow for the act to be used by way of production of material, as opposed to what exists lawfully right now, on which this bill preserves, which is where you go for warrants for stored data or communication data under the provisions of Section 5 of the Preliminary Inquiries legislation, or if you go for that data pursuant to production orders under Sections 32 and 33 of the Proceeds of Crime Act. So the law allows that in two subsidiary pieces, in two other pieces of law, which is the Preliminary Inquiries legislation effectively, Section 5, and the Proceeds of Crime Act, Sections 32 and 33. But what we have to do here is to incorporate that into this legislation. Now, Madam Speaker, very importantly, we include a definition of a prison. And we have borrowed from the miscellaneous provisions, Law Enforcement Officers Bill, a wide definition of prison to include rehabilitation centers, prison detention centers, etc. And therefore, you'll see a definition of prison there. Madam Speaker, it is important to note that we've defined traffic data. And traffic data, again, allows us this pinpointing opportunity to triangulate where you were when the crime was committed if the evidence was intercepted. Madam Speaker, it's very important to note that we propose a specific inclusion in Section 4A of what the Act applies to. Under the existing law, the Act applies to criminal proceedings. You will see, Madam Speaker, in the bill before us that we've proposed the insertion of a Clause 4A, Section 4A, and Section 4A now broadens this application of the law, firstly to criminal proceedings, obviously, but secondly, Madam Speaker, to the provisions of the Anti-Terrorism Act, the Civil Asset Forfeiture and Explain Your Wealth suite of legislation, and very importantly, the Mutual Assistance in Criminal Matters Act for extradition matters. In other words then, criminal and quasi-criminal law must be contemplated as interception of communication ought to be confined to those circumstances. Madam Speaker, we then look specifically to the improvements that we see in Clause 6. In Clause 6, we have split it into an either-way offense, moving from more than just summary conviction into indictable, because we would like to move away from the limitation of a 6-month period of limitation for summary matters. Madam Speaker, the amendments that we see coming into the further provisions of the law, and if we get specifically to what we are looking at in Clause 6 and Clause 7 combined, we can see, Madam Speaker, that we are allowing in Clause 6 the amendment of the law, which is the amendment to the heart and soul of interception. We are allowing in Clause 6 that communications intercepted may be subject to section 17(2)(b) and 2(c), admissible in evidence. Where you have interception under the Interception of Communication Act, you can have it under warrant, you can have it without warrant, but the old law, the law we propose to amend, says you can't use that evidence that is non-warranted. We are now saying that you can be allowed to use non-warranted evidence subject to the safeguards built in new clause 17, new section 17(2)(b) and 2(c), only for proceedings which are defined in clause 4 as the broader than criminal proceedings, quasi-criminal proceedings, anti-terrorism, mutual assistance, and extradition, obviously, Madam Speaker. Madam Speaker, we are allowing in clause 7 for the Commissioner of Prisons to provide the proportionate balance to the intrusion of prisoners' rights. Now, prisoners' rights are modified rights. It is clear in law that prisoners don't enjoy the full panoply of rights that normal citizens do because they are under conditions of detention when sent to a prison. We are requiring in new 6A by clause 7 that the Commissioner of Prisons must give notice that the prisons are effectively a listening place in all places except the areas set aside for legal professional privilege. The legal professional privilege must be carefully preserved, and that is done by clause 7. Madam Speaker, clause 7 also adds in the new section 6B, and section 6B allows us to intercept prison vehicles. Now, it's important to remember that these interceptions are not over a telecommunications network. They are, in fact, recordings of communication, and therefore the Interception of Communication Act is now going to more than just interception on a telecoms network and into bugging or recording of only prisons or prisons vehicles. We note the opposition has been on the outside saying that this allows everybody to be intercepted by way of recording. That is not the case. Madam President, Madam Speaker, we have sought in clause 9 to amend section 8 of the Act specifically so that you can have a warrant for interception for more than just the communication on the telecoms network. Here is where we add the stored communication or stored data, and therefore we broaden the Proceeds of Crime Act and the preliminary inquiries route by allowing for data to be produced at the High Court, information at the High Court, not only via the magisterial production order under Proceeds of Crime Act or warrant under the preliminary inquiries route section 5. Madam Speaker, we've also added in the provisions of the mutual assistance in legal matters, and you will see that where we amend section 2A by adding in a Roman 3 to that to include mutual assistance in matters. Very importantly, Madam Speaker, you'll note that we're treating with the concept of sensitive information. And we have specifically in the sensitive information sought, when we get to the amendments to section 17 and to section 19, to treat with that in a very different way. Clause 10, Madam Speaker, is an important provision. Here is where we ask the telecommunications providers who are under license to bear the cost of assisting in interception of communication. The current position right now is that they ask for exorbitant fees for the technology to be brought up to their level when instead they can provide the access using their own technology. Madam Speaker, clause 11 treats with the amendments to urgent applications. Again, we've broadened to include stored communication and stored data. Madam Speaker, clause 12 is an amplification of what we did at clause 10, where again we put the cost upon the telecommunications provider in adding the assistance. Madam Speaker, it's very important to note that clause 12A is where we seek to improve the Act by making sure we extend the confidentiality provisions that are provided in clauses 14 and 15, in clause 14, to all of the routes, not only stored communication, not only intercepted communications on a telecommunications network, but also stored communication and stored data. Madam Speaker, in clause 13, we again treat with the acknowledgement that you can have interception and production of information via the Proceeds of Crime Act and the preliminary inquiries legislation. Clause 14 introduces further safeguards in respect of keys which are used for management of access to telecommunications network or secured communications. Let's get to Clause 15 quickly. Clause 15 is where we treat with the ouster of the court. This is the unconstitutional part of the 2010 law. In Section 17, we had the unfortunate position where the court was not permitted to consider the admissibility of evidence. And I'd like to warn, it is at this point that I must caution that the Director of Public Prosecutions specifically informed the Attorney General's office that there was a need to treat with this amendment. The wide stakeholder consultation that we had also underwrote this, and therefore this law is critical to making sure that prosecutions under the Interception of Communication Act have a chance at success. Madam Speaker, we have specifically introduced into this that what is in fact the sensitive information. We've included the bracket of the warrant, because for the evidence to be made admissible, you need to know who made it, in what circumstances, and how. And we have to protect the law enforcement agencies by making sure that the identity of those persons in national security remain a national security issue as it is all over the world. We put in very critical safeguards to ensure that the interception of communication for prisons, etc., are matters that must be subjected to subclause 2C. And here is where we put in the Bailey principles as they're referred to from the common law. That is, that nothing was done to induce or trick the accused or defendant. The integrity of the recording or interception is sound. The use of the recording or interception device is proportionate to the gravity of the alleged or suspected offense. The use of the method was appropriate. No recording or interception of any legal professional privilege took place. These are critical safeguards in balancing what we do here. And Madam Speaker, we ensure that there is a satisfaction of relevance. The court must consider granting leave, but the court must consider granting leave in the circumstances set out in the new subsection B. It shall not grant leave in relation to evidence or questions referred to unless it is satisfied that there is a validity and lawfulness of the warrant, the accuracy of the integrity of the intercepted communication, the accuracy and interception of the communication data. And Madam Speaker, when we look to the provisions a little bit further, we also deal with the usual aspects. The preservation of the rights under the Evidence Act, Section 14A and Section 14B. Madam Speaker, we've introduced a critically important provision via Clause 16. Clause 16 introduces a special measure. If you want access to the sensitive information, if you want to find out the identity of the person who did the interception and put them at risk, you must go through a special measure, and that special measure has to be underwritten by a court and only a court giving you leave. That special measure introduces a special advocate. That special advocate preserves the right of the defendant under the principles of legal professional privilege for the defendant to be represented by an independent person on a narrow scope only, and that is the admissibility of the sensitive personal information or privileged information. This has been accepted in the Commonwealth around the world, the United Kingdom, Canada, New Zealand. In those jurisdictions, they do it administratively, not judicially. We seek in this bill to give judicial discretion, therefore bringing to life the due process aspect of the law and giving constitutionality. Whether that proportionality is underwritten by a narrow proportionality or an extended proportionality within the meaning of narrow in the Barry Francis aspect of the case in our own Court of Appeal, or in the Lady Hale aspect of the Surratt case, or in the extended proportionality of R.V. Oakes and De Freitas, etc., which latter part doesn't necessarily apply to us. We have underwritten due process into this matrix in a very careful way in Clause 16. We obviously prepare and keep the interest of justice and the legal professional privilege caveats into position. Madam Speaker, in Clause 17A, we propose the preservation of the Proceeds of Crime Act and interception via the preliminary inquiries route, but those laws were not subjected to the safeguards in the Interception of Communication Act. So we have put in the specific springboard, and you see it in the consequential amendments to the Proceeds of Crime Act, and also to the preliminary inquiries route, where we lift the provisions of Section 13 and Section 14 of this Act to make sure that confidentiality is preserved, to make sure that tipping off does not happen, so that the police are in a very careful circumstance of preserving intercepted communication, whether it is under the Interception of Communication Act, the Proceeds of Crime Act, or the preliminary inquiries legislation, Madam Speaker, and I'm using that term in the short sense of the word, of the phrase that we apply that law to. Madam Speaker, Clause 18 treats with the admissibility of stored communication and stored data. We have replicated the provisions for leave. We have replicated the safeguards. We have managed that in a careful way. Clause 19 is where we make sure that there's a destruction of records, and we have gone further to make sure by improvements that we preserve a critical concept here. Right now, there is no savings of intercepted communication. There's a requirement for it to be destroyed immediately if it's not going to be used in proceedings. And if that information discloses criminal activity in relation to another matter, it is destroyed. We have preserved in the new subsection 8 the concept of public interest immunity. And public interest immunity is underwritten well. Actually, the cases are from the Privy Council, from the European courts, from the rest of the Commonwealth. The public interest immunity is a very careful issue that preserves evidence, and we keep that specifically in place under the new subsections 8 and 9 of Section 20. Clause 20 treats with amendments for general provisions the protection of authorized officers. Clause 21 treats with offenses. We are making sure that we add on what exists under any other written law, and by that, obviously, we mean, for now, the Proceeds of Crime Act and the preliminary inquiries route. Clause 22 introduces the new Section 23A, and that is the tipping off offense. This is critical, where criminality exists in tipping off, where politicians seem to have evidence in their pocket or on a public platform, as we saw announced quite spectacularly by past Attorney General Ram Logan, for example. These things must be stamped out. Madam Speaker, we then turn to the amendments brought via Clause 23. Clause 23, we introduce the concept of regulations, and we've raised the offenses to take care of Section 63 of the Interpretation Act. We've elevated a breach of regulation to a fine of $250,000 or imprisonment for 2 years, and we've specifically introduced the rules-making capacity of the judiciary under Section 25A, Clause 25A, where we allow the Supreme Court of Judicature Act to go into operation to make rules. Clause 25 treats with the application of warrants amendments, adding in stored communication and stored data. Clause 26 deals with the same addition to Schedule 2. The first one was Schedule 1, that's Clause 25 was Schedule 1. Clause 26 treats with the addition of stored communication and stored data. Madam Speaker, the rest of the provisions deal with the amendments that we had to make to the Proceeds of Crime Act and the preliminary inquiries route to make sure that information which was produced under the production orders in Sections 32 and Sections 33 of the Proceeds of Crime Act, or via Section 5 of the preliminary inquiries route, that those are subjected to the same degree of confidentiality and caution that we have. In a nutshell, Madam Speaker, it is time to make a prison a prison. It is time to make sure that criminality does not prosper because we are afraid to use technology. It is time to bring Trinidad and Tobago in line with the rest of the Commonwealth and the common law. This law is proportionate in every sense of the word. This law has been brought with full independent support, not a single no coming from the independent bench. This law stands as a crime-fighting tool to return Trinidad and Tobago to a sense of normalcy. This law articulates with all of the deep reforms that we have engaged in as a government into the criminal justice system, be it at its core or be it at its periphery, reduction of caseload, opening of more courts, etc. This law is before us for debate. I look forward to contributions, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Interception of Communications Act Chapter 1508 be now read a second time. Member for Oropouche East.
Thank you. Thank you very much, Madam Speaker, for the opportunity to speak on this extremely important measure before us today. Madam Speaker, let me say from the beginning, I intend to take all 30 minutes of my time and to divide that time after some introductory remarks into an assessment of the legislation, the parent legislation so far, and of course some critical thoughts on the amendment bill before us. My colleagues after, attorneys at law, would speak in greater detail on some of the issues raised by the Attorney General as they relate to specific amendments to the operationalization of the measures, and of course to the introduction of new concepts and new legal personalities into the structure of our justice system. Madam Speaker, just a few thoughts first on the presentation made a few moments ago. And I believe, and I say so without any reservation, that the Attorney General means well and would diligently do his research, and as well-intentioned as he is, he will not go beyond a certain boundary and will, of course, share deep concern with the issues of democracy, of fairness, and of justice. Madam Speaker, this bill must be placed in the context of where we are today as a country, where we are today in the electoral cycle, and where we are today in the fight against crime. The fight against crime and criminal elements did not begin this morning. Madam Speaker, that has been a battle facing this country for over 25, 30 years, particularly in the aftermath of the 1990 events, where I believe the offspring of one of the key protagonists is now in the news again. Madam Speaker, the issue here is that this is the tail end, the 11th hour of an administration in its 5th year, and one wonders whether the administration itself has the moral authority to bring this piece of legislation. Because this legislation is rooted in public trust. Governments are extremely wary of dealing and advancing this type of legislation because it requires public trust. And if we ask ourselves the question, does this government enjoy the public trust of the national community today to give them the moral authority to ask for this type of power to government agencies, some of which are not completely independent of the political executive? And the question is, do you have that trust? We believe you don't, because we are mere weeks away from the dissolution of the parliament and the calling of a general election, and it is unwise, to say the least, that a government can now claim from the people, can now ask for this right. Madam Speaker, the issue of trust is there, I'll come back to that, but we have in our possession reports, Madam Speaker, on the performance of the parent legislation, and the Attorney General was right. This legislation came into being with the People's Partnership in December 2010 because of a series of events which was scandalous, to say the least, and involved the illegal wiretapping, illegal eavesdropping, and to use a language that people know, the macking of public officials at the highest level, Madam Speaker, right through the government, the private sector, trade unions, members of the political opposition, and so on. And that history is there. The former Prime Minister, member for Siparia, came to this very chamber and spoke on this matter and showed the files. And therefore, we moved to put in this interception of communication legislation to really create the legal framework for intelligence gathering according to the law and to help law enforcement. Madam Speaker, we have in our possession the reports, and the reports, Madam Speaker, Interception of Communications Act, Chapter 1508, annual report. And I don't want to go through all in the limited time I have, but to just share a particular view and raise a particular concern. Now, the government is in possession of not only information, but, Madam Speaker, the government is in a position where they can clarify, where they can get their technical expertise to help us out with understanding technical terms and understanding technical reports. But, Madam Speaker, I just want to relay some information quickly, and I'll use 2014, the annual report for 2014. Madam Speaker, in 2014, we are told by the annual report that the Commissioner of Police, through the SSA, the nature and number of interceptions made pursuant to the warrants granted, 479,915 for speech, data 208,000, done through the SSA. Madam Speaker, the Director of Strategic Services Agency, number of interceptions made pursuant to the warrants granted, same year, Madam Speaker, so we are in 2014, 479,915, data 208,000. Madam Speaker, it's very instructive that from day one, while the Chief of Defense Staff is an authorized officer under the legislation to undertake interceptions, Madam Speaker, in this report, in the column to suggest number of warrants applied for, number of warrants granted, number of warrants applied pursuant to this legislation, number of interceptions, everything is nil, 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 nil. So the Chief of Defense Force from 2014, and it could be from before, but I'm just using 2014. It was the last full year of an administration. The Chief of Defense Force apparently is not involved too much in this business. But Madam Speaker, I quoted just now the number of interceptions and so on. Let us go to 2016. Madam Speaker, 2016, number of warrants granted to the Commissioner of Police, 36. Number of warrants applied for and granted under the Interception of Communication legislation, nil. Number of applications made for new renewal, nil. The number and nature of interceptions made pursuant to warrants granted. This is instructive, Madam Speaker. For the Commissioner of Police in the 2016 period, 145,000, more or less. Madam Speaker, in 2016, the Director of Strategic Services Agency, number and nature of interceptions made pursuant to the warrants granted and so on, 283,418 for speech, 70,000 for data, more or less, Madam Speaker. Madam Speaker, when you read through the record, and it is now it is public record, the number of persons arrested whose identity became known as a result of interception, nil. Number of criminal proceedings commenced by the state in which private communications obtained through interception were adduced in evidence, nil. Number of criminal investigations in which information obtained as a result of interception, nil. Number of prosecutions commenced under sections of the Act, nil. 2016. Madam Speaker, I go to 2017. I believe this is now the latest report we have. Let's go again. This is now increasing. The number of interceptions increasing, Madam Speaker. So, through the SSA, we have had, Madam Speaker, we have had 551,466 through the SSA. For the Commissioner of Police, another 500. So, Madam Speaker, what we are doing here, and it is not clear at all in the way it's reported, but I can tell you, in 2017, we have had 972,000 interceptions between speech and data. Almost 1 million interceptions for speech and data. Madam Speaker, the number of people arrested, 5. Number of criminal proceedings commenced in which interception material could be used, nil. Madam Speaker, that is 1 million interceptions, 1 million points of macroing for this spy bill, for which no one has been convicted, and for which 5 persons have been arrested. Madam Speaker, and the areas in which it's done is generally murder, shooting, wounding with intent, dangerous drugs, and so on, Madam Speaker. So that is the first point that startles you, that we have interceptions of 1 million points of interception, but we are not reflecting that anywhere in terms of arrests, in terms of ongoing criminal proceedings, in terms of convictions. Madam Speaker, and you come today to make the most diabolical change to this legislation, Madam Speaker, the most diabolical of all, to effectively now indicate to this country that you want the right to use interceptions that are not warranted, that you get by without a warrant. You want to put that into evidence against persons. Madam Speaker, let me say from the outstart, this is not the Interception of Communications Amendment Bill. It is not. This government has now a knack for misleading, for willfully doing things, Madam Speaker, in a way that is not 100% online. And Madam Speaker, why don't the government be honest with us and call this bill the Interception of Communications and Stored Data Bill? Because this is about stored data. It is not interception of communications alone. Madam Speaker, in the world of international criminality, which we follow, some of us on TV, movies, but some of us by reading journals and so on, we well know that terrorist elements and major crime elements, what they do, they store data, and they have methods of exchanging information on stored data that are never transmitted. So we all know law enforcement has a challenge, not a new challenge, incidentally, where, for example, and I'll give a quick example on this. Someone could have an email, and they write in an email instructions on manufacturing or producing an explosive, but they never send that email. They store it in their computer in a draft box. But the person who needs to read that is in another jurisdiction, another part of the world, so to speak. And that person never receives an email. But he has the encryption codes and the password for an email address. He goes with that, he digs up inside there, he goes into the draft box, and he gets his instructions. But that was never transmitted. It was never transmitted, so it cannot be intercepted. And that is a challenge. So you want now this ability to go and get stored data. But the government should be honest with us and call the bill the Interception of Communications and Stored Data Act. So we will understand what they want, Madam Speaker. They want this ability to use evidence, to make evidence out of intelligence that they get from listening in. In another place, the Minister of National Security told us that, Madam Speaker, I will now stretch myself to get proper language because I do not want to run afoul of the standing orders. The Minister of National Security, we have his contribution here in another place, and the Minister of National Security on several occasions has, with monotonous frequency, tells us about confidential information received from police. Tells us that he receives intelligence reports, and tells us about information received from police and so on, and what they are doing and what they are not doing. And later in the proceedings, he may tell us more. And on one hand, told us in the other place that I can't tell you more because they only tell me the nature of the issue and number and code. They don't call names. But then went and called names of members of the opposition as a result of interception. Madam Speaker, I am a victim of that. I am a victim of the abuse of officials of this government using purporting to use intercepted communications. This is why citizens are not free in this country. Because you can manufacture anything you want and say that is intercepted. Take it out of context, Madam Speaker. Neither myself or any member of the opposition, I can't tell you for the last 5 years, has ever been called, reached out, contacted by the police concerning any matter related to criminality, gang warfare, and criminals and so on. But our names are called. It is by officials that have gone rogue. And they expect you now to trust them with this material. With material that are not under warrant to put that into evidence. That is a danger that this country faces. Madam Speaker, I want to get to the bill. There's a
Madam
particular
Speaker, stand in
section
order,
6,
48.6, please.
that deals section 6 of the bill. Oh, sorry. What happened?
Remember, there was an objection on the standing order 46. I uphold the objection.
Okay. Thank you. I'll move on now.
No, so if you could just withdraw that part of the statement.
Okay, sure, withdrawn. Whatever it was. Madam Speaker, section 6. In section 6, we have an interesting area here. It is 7, but really it is the amendment to 6A and B, in which we are saying that this is related as well, Madam Speaker, to communications in prisons and so on, staff of the prisons and so on. My colleague, a member for Approach West and others, will speak about that issue of legal professional privilege and the implications of the bill and so on. I don't want to spend too much time on that, Madam Speaker. But the Commissioner of Prisons will indicate to the prisoners, prison staff and so on, that the prison is now a site of listening. So anything you say and do, of course, can be heard and can be used and so on. Madam Speaker, if the government is concerned with a particular problem, and I understand the problem is that you are saying, you have intelligence to suggest that persons, when they're in prison, they put out a hit. They put out a hit on persons outside, and you have picked it up by way of intelligence and interception of communications. Okay, that deals with murder, that deals with shooting with intent, that deals with firearm. Why don't you redo the bill that deals only with that? That deals with shooting, murder, firearm possession, threats to kill from prison, and bring a part of the bill that deals with that, and maybe we can consider whether intelligence gathered in those specific circumstances should be used as evidence in the court without a warrant. But they come with this entire carte blanche bill to say, this is about prisoners, and later after me, somebody will stand up here and say, why should a prison be not a prison, and a prison should be a prison, and prisoners shouldn't have contraband phones. They shouldn't have contraband phones in the first place. We passed a law here, the opposition supported it, Miscellaneous Provisions Law Enforcement Officers Bill, in which we made illegal having a cell phone by a prisoner. So the government comes today and says, listen, we know it's illegal, but we can't do nothing about that. 5 years now, we have jammers and, what is the next word? Jammers and grabbers, technology to put in the prison to prevent people from even making a call. We cannot implement that, jammers and grabbers legislation and policy. So we give up on that. We just give up. We say, look, prisoners will have phone, they'll have phone. Let's intercept now. And you come today to get the right to intercept and use that as evidence, but not only for prison, for every single person. And with serious implications for the protection of lawyer-client privilege. Serious implications. Madam Speaker, this has a danger to it. You see, prisoners as well, there are many cases, and the Minister of National Security told another place that he received a voice note from what he believed to be a prisoner, telling him, we have to talk. Now, could you imagine a case? That is a real issue. The Minister of National Security actually said that. Record is there. And he can't deny it. Could you imagine a prisoner sends a voice note to a journalist and say, I am innocent, they set me up, I have information on government ministers and businessmen or whoever. They take that stored information and use in a court as evidence.
Please, I'll give you some latitude to continue.
I can proceed. Thank you. Thank you. So stored information in the form of a voice note, that is stored information, goes to a reporter. The journalist now face herself or himself with serious legal consequences having that, because that information is not just intelligence as it was before, it is evidence. And Madam Speaker, today there is a blatant and obscene attack on the media houses, on journalists. It is jail for journalists with this piece of legislation. Because Section 6 speaks to...
Member, I'll ask you, you see that last part there, which is not factual, but a sort of assumption you're making. To me, that is imputing improper motives. I'll ask you to retract that, please.
Okay, sure. Thank you. So, Madam Speaker...
Yeah, so you retract that?
Yes, Madam Speaker. Madam Speaker, professionals in this country, whether they're journalists or anybody else, I don't want to focus only on journalists, Madam Speaker. It could be attorneys at law, it could be trade union leaders, it could be religious leaders receiving a voicemail from a prisoner is now trapped in this legislation that could go to court as evidence and they could be charged with conspiracy to murder or to commit a serious criminal offense, Madam Speaker. And that is a danger that this bill will put to us, Madam Speaker. Madam Speaker, the next issue, and I want to move quickly because you know, we know it's here. I want to look at Section 8, Madam Speaker, and an amendment to Section 8. And the Attorney General spoke, I think, in some depth with this issue, Madam Speaker, of Mutual Assistance in Criminal Matters Act and giving effect to the provisions of any international mutual assistance agreement. Madam Speaker, so that the information gathered here, the evidence as it will be, if this is ever passed, can be used in mutual assistance matters as well, where it can go to a foreign jurisdiction and be used in their courts of law to pronounce on someone whether they're innocent or guilty. Madam Speaker, we have also, as politicians, received information. Madam Speaker, politicians receive information all the time on what citizens consider to be suspicious activity. That is the nature of politics in this country, Madam Speaker. When we receive that information, we are not always in the chamber. We don't get a letter in the chamber and we speak in the chamber and we get the immunity in the chamber. We are in our offices, in our homes, in our place of work, Madam Speaker. And politicians, opposition politicians, it will be, whoever is in opposition, will face a risk with this matter as well. So, Madam Speaker, hypothetically, I can tell you, if we receive information, Madam Speaker, that this government acted unlawfully on April 23rd by filing a reservation to the Organization of American States to reserve their position on decisions taken in December last year on the Rio Treaty, is that an interception that we could go to jail for? Madam Speaker, the government went, Minister of Foreign Affairs, on April 23rd this year to file a reservation to undo, Madam Speaker, their breaking of an international treaty under this area. They breached an international treaty. When they got caught, they filed a reservation after the fact. That could be... Oh, sorry.
Standing Order 48.1, please.
Please continue.
Thank you very much, Madam Speaker. Madam Speaker, information reaching any member of the society, forget politicians for a minute then, because if that affects you. Madam Speaker, information reaching any member of the society on this matter, once you get it in interception form, it becomes evidence. So I do not want at any time to put myself and make myself the center of this, although I said before, I am a victim in that sense. But Madam Speaker, if I am to say today that I have received word that the United States administration has already written a letter to Foreign Affairs warning this country of sanctions, to personal sanctions to government officials and their spouses. And if we have learned this today as a matter that is now developing, could you therefore come now with interception of communications, look at my device, find out where I got this from, who sent it to me, because it is stored data. And stored data doesn't mean that you have data on your phone. Huh? You could delete it, it is still stored. Stored data, so people who think they could go on their phone and just delete, think again. So if I have information like that, and the government wants to prosecute now, it is no longer intelligence, it is evidence. You can use that in the courthouse, Madam Speaker. And that is the danger we face. Then they tell us that what we call the special advocate, and my colleague will deal with that. This is called secret justice in the United Kingdom, special advocates. It's called secret justice. And we'll deal with it later. They tell us that this is following the British tradition, and the British have it. This country, under this government, cannot follow any tradition except Venezuela. They cannot follow tradition of England at all. Because, Madam Speaker, in England, that is creating a problem. We have critical papers now on the use of this special advocate that is not paid by a client, is not representing the client. The client may not like him or her. A special advocate could be anybody. They're throwing out people left, right, and center. The member for San Fernando, he says a lawyer, he could be the special advocate next 2 months. Madam Speaker, so that special advocate comes in now in a context where this government said that is from England. Madam Speaker, in England just the other day, would you believe a British minister resigned because his personal assistant violated the lockdown rules? In this country, a minister don't want to resign when he was found lying to an American ambassador.
Madam
Speaker.
Madam Speaker, I withdraw that. I should say it in a more
and
circular way.
apologize.
Member, I'll ask you to withdraw it and apologize and press
Okay,
on.
I withdraw and
As you started off well, you said you don't want to run afoul.
Yeah, Madam Speaker, I will withdraw and apologize, but I'd like to say it in another way, without offending anyone.
So you've withdrawn and apologized.
Sure.
And you could proceed once you keep with
Yeah, sure. I will say it within the standing orders. In the United Kingdom, a personal assistant resigned, a minister resigned because his personal assistant broke the lockdown order. In this country, no minister will resign, even if they are found lying. Madam Speaker, I call no names and I point out to no names.
And the point about it is this. Of course, you know, there are certain things that we consider unparliamentary.
Sure.
And I think with your experience
Yes.
and your breadth of language, you can find another way to see,
Sure.
to see that. Please. So withdraw it, and I'm sure.
I will
with
withdraw
your
that as
skill.
well. Let me say, if there are anybody at all who is allergic to the truth, you like that. If anyone is allergic to the truth, they will not resign, even when caught, Madam Speaker. And I move on one time. I don't want to dwell on that. Madam Speaker, the other major issue here, and I think a colleague may even deal with it as well after, is this issue of all proceedings. When we introduced this legislation, it was to deal specifically with criminal matters. Today, the government is coming with a bill and say all proceedings, civil matters as well as criminal matters. I am not sure how that works in practice. I read it. I'm not sure how you work that out in practice, because civil matters are matters where there are two private parties as well. You can have a government. Madam Speaker, CPEP sue me. The EMBDC sue me. They wanted HDC to sue me. I mean, everybody. So the government is taking civil action. They always do that, many governments. But civil matters involve private parties as well. So what happens here? A private party can somehow bring intercepted material. A private party cannot bring intercepted material because they'd be in violations of the law. Remember, according to the law, the Parent Act as well, that is not changing. You cannot be involved in intercepting communication. So it is only the government will have intercepted communication. So when the government decides when they decide that they don't have evidence for criminal proceedings, nobody break the criminal law, but we don't need DPP, we can sue everybody in civil action. They now come with intercepted and stored data against citizens of Trinidad and Tobago who will not have that advantage to get intercepted communication. And if they get intercepted communication, they could be breaking the law as well. Because if you have documents and materials on you that suggest that this is intercepted material from the police or the defense force, you are breaking the law, Madam Speaker. So this bill is completely unfair. It is unfair, it is unjust. And they are coming today to use prisoners as a cover. As a cover. Today they are using prisoners as a veil for a deeper, diabolical measure of tyranny to create a dictatorship here, a la Maduro.
Speaker, stand on order
Madam
48.
Speaker.
Madam Speaker, stand on order 48.6, please.
What is that now?
Remember, it's in respect of a particular word
Sure.
that you have used. And don't repeat the word, but it's in respect to the word tyranny. And so I would ask you just to withdraw.
Okay, Madam
those
Speaker.
words, please.
Madam Speaker, I have no difficulty. So, Madam Speaker, the bill poses a danger on several fronts. This special advocate matter, this civil and criminal proceeding, this across-the-board attempt to convert 1 million pieces of Macoin into evidence without a warrant. You see how it worked and how it's supposed to work is that if you have cause to intercept and so on, you could intercept. If you believe someone is involved, for example, Madam Speaker, I only give an example. It is not real and so on. If you believe someone is selling fuel to Venezuela and in breach of international law, you may want to intercept communications. to pick up the intelligence. When you pick up the intelligence, you go before a judge and say, Mr. Judge or Madam Justice, this is what we have picked up. We will now like a warrant for 90 days to intercept communications from this particular person because we believe criminal offenses have been or are about to be committed. And you can get it. Take your 90 days, gather your evidence, and then come to your court with a charge. No, the government is not interested in that. They're not interested in that. They're interested as from the time they pick up something. So two people in the BTAM talking. They call the name of one member of parliament. You say, aha, we have him. That is not warrant. So let me make that non-warranted evidence. We have him. This is how they are, Madam Speaker. This is how they will approach it, and it is a danger, a clear and present danger to Trinidad and Tobago. That's it? Oh, thank you very much, Madam Speaker.
Member for Port of Spain North, St. Anne's West.
Thank you very much, Madam Speaker. Madam Speaker, I apologize for the delay with these new arrangements. It takes a while to set yourself up. Madam Speaker, in my abbreviated in time contribution, I'd like to get us back on track. I'd like to get the House squarely back on track and dealing with what the amendments before us are here today. I'd get to the standing order with respect to conflicts of interest, and when members are making certain declarations and debating with respect to legislation, that there's a standing order that they should declare their conflict of interest up front, and in particular the potential breaches by the member for Urupuch East a short while ago. So, Madam Speaker, this bill, for those who are listening, the members of public who are attentively listening, and for those who are interested in the truth, is about amending the Interception of Communication Act in very, very specific circumstances. And this bill really is seeking to allow for interception of communications from prisons and vehicles used to transport prisoners, and for these communications to be recorded and in some instances to be used for evidence. Madam Speaker, the importance of interception is known. It's always a balancing exercise. In national security, you're constantly balancing the protection of the state and its citizens and their safety and security versus the protection of individual privacy. It is well recognized the world over that intercept is a necessary component in the fight against crime and criminality. With today's use of technology by everyone, intercept has become even more prevalent, more relevant. And what I'd like to start off by very quickly assuring the public of Trinidad and Tobago about is the Interception of Communication Act. The parent legislation in its current form already has all of the necessary safeguards to protect our privacy rights. So to dive straight into the heart of what we're looking at here today, we're dealing with the prison system. And I would like any law-abiding citizen, any civic-minded citizen, to listen very carefully to the arguments that may be put forward here today, because there can be absolutely no sensible, legitimate, or legal position taken that a prisoner should have the right to talk on a contraband cell phone or use a contraband tablet, an illegal cell phone and an illegal tablet, to talk to anyone on the outside of prison walls. So let the population look on, let them listen very carefully as to who is going to put forward a proposition that an illegal cell phone, because they are not legal, It is contraband to have a cell phone and a tablet and any such type instrument as a prisoner in a prison to communicate with anyone outside. And I'd like to assure the public of Trinidad and Tobago that there are already circumstances set up in our prison system to permit prisoners to legitimately and legally speak to their lawyers. There are landlines there set up in prison. These landlines even have a system where family members can pay for you to get credits to use those landlines to speak to persons on the outside. Every prisoner has the right to use those landlines that are there. Your lawyers, your family members are provided with rights of audience. They can come in, they can meet with you, they can talk with you. So there is no breach whatsoever of a prisoner's ability to converse legally with anyone he so chooses to, either via landlines or a physical meeting. What this legislation is aiming to do is deal with a worldwide and a global phenomenon. And I was waiting to hear it being suggested, and it was, as usual. Remember for Urupuch East talking about grabbers and jammers and how it can be utilized and worked. I'd like to start off very quickly, Madam Speaker, by just two jurisdictions, because these are the two jurisdictions that are very often used as sophisticated first world jurisdictions. That is the United Kingdom and the United States. That the member for Urupuch East all of a sudden seems to have a love for the United States. So, I'd like to first of all, Madam Speaker, through you to refer to a report commissioned by Her Majesty's Prison and Probation Service, the demand for and use of illicit phones in prison. Ministry of Justice Analytical Series 2018. So this is a report commissioned by the prison services in the United Kingdom with respect to the illegal and illicit use of phones in their prison system. And I'd just like to briefly take us a few paragraphs so we understand the context. And this is not something that Trinidad and Tobago alone is facing. Key findings at paragraph 1.3. The scale and type of mobile phone use. Heads of security in the surveyed establishments, meaning the prison systems in the United Kingdom, identified the trafficking of illicit mobile phones as one of the major risks they face in maintaining prison discipline and providing a decent and secure environment. The perceived scale of illicit mobile phone usage varied widely between these establishments and prison types. Heads of security reported that mobile phones had become a feature of prison life across the estate, with the exception of women's prisons and those housing juveniles. Mobile phones were seen by both the security function and prisoners as a major component of the illicit prison economy, with mobile phones acting as a key facilitator of drug dealing and use within establishments. This is the United Kingdom, talking about what is taking place in the United Kingdom. They go on at page 5. Heads of security identified that illicit mobile phones could enter prisons through a number of ways. Over-the-wall packages and offenders entering prison were most commonly highlighted by them as routes of entry. Paragraph 1.4, the conclusions in the executive summary. Mobile phones were viewed as a feature of prison life, across the custodial estate, although rarer in both women's prisons and among the youngest prisoners. They were seen by heads of security to be creating significant problems within prisons and for prisoner management. Significant criminal drivers for the trafficking and use of mobile phones within prisons were reported, with mobile phones being linked to criminal activity both within and outside the walls. This is the United Kingdom. It's happening right there with all of the technology, all of the money in the world. And the report goes on to make a number of findings and a number of recommendations. The point being, Madam Speaker, this is not limited to Trinidad and Tobago alone, but this government and this administration will not allow the promotion of criminal activity, and that is what this legislation is about. So all of the fear-mongering that we heard from Urupuch East, not surprising, and I'll come to that in a short while. Another article I'd like to refer to, dated April 19th, 2020, Will Cell Phones Be the Downfall of Prisons? This is from Forbes magazine. The author is Walter ParlView. The Federal Bureau of Prisons has tried to address the growing problem of cell phones in the hands of incarcerated inmates. In the event you do not know, cell phones and iPads, Microsoft Surface, are illegal in federal prisons. However, they are everywhere in prisons across the country. This is in April of this year in the United States. Congress passed a Contraband Cell Phone Act that prohibits the possession of cell phones in prisons by unauthorized persons like inmates. And the article continues talking about the challenges. The cell phone contraband problem in prisons was listed as one of the top challenges for the Bureau of Prisons in a United States Department of Justice Office of Inspector General report last October. The report cited an incident where cell phones were used to coordinate a deadly attack on a Bureau of Prisons corrections officer in Puerto Rico. I pause there. In the United States, they're identifying the use of contraband and illegal cell phones as a problem they are facing and talking about incarcerated prisoners using these cell phones to call a hit on a prison officer outside. That is what we have faced live and direct here in Trinidad. So this amendment that has been brought here to this House today, the population looking on, is to allow us, when we intercept those types of phone calls, to utilize the evidence against the perpetrators. What can be wrong with that? But instead, we come here to hear about all sorts of distractions. This legislation is to allow law enforcement. This legislation is to allow law enforcement in Trinidad and Tobago, when they intercept phone calls by prisoners, incarcerated criminals on the inside, engaging in criminal activity on the outside, all the way up to calling hits on persons, for that to be used as evidence. What could be wrong about that? And the attempt to misconstrue it and to tie it into the politics and to be talking about it being used. Maybe my friend for Urupuch East believes he will be in prison. I don't know. This is to deal with the life of those who are in prison, communicating with those on the outside. So this legislation affects persons who know they're engaging in criminal activity with prisoners on the inside using illegal phones to speak to them on the outside. And maybe that is the sense of nervousness. I don't know. Another article, contraband cell phones in prisons quickly becoming a national crisis. This is not Trinidad and Tobago. This is an article, Sinclair Broadcast Group by Ann Emerson, Tuesday, December 11, 2018, in Washington, the capital of the United States. And it says, cell phones are just about everywhere these days, including, it turns out, our nation's prisons. They're dropped in by drones, thrown over jail walls, and even smuggled in by correction officers, and it's all illegal. This week's Spotlight on America investigation found that lockups nationwide are flooded with contraband phones. They're being used to plot escapes, run criminal networks outside prison walls, and call in hits. Washington, D.C. in the United States, United Kingdom. So, Madam Speaker, what we're dealing with here is a global phenomenon. What we're dealing with here is we're looking to pass legislation to allow law enforcement, when they intercept these types of phone calls, to prosecute people to use the evidence. I heard all of the reference to the stored data. It was quite interesting that the member for Urupuch East, and he tries to blame it on television programs, was giving us chapter and verse how it can be done. Do an email, keep it in a draft box, let somebody else read it. That was news to me. Stored data here allows the law enforcement authorities, with all of the protections of the Act and all of the protections of the criminal law, when they get someone's cell phone, an illegal contraband phone in prison or in a prison van, to take that phone and forensically lift from the phone all of the types of activity and conversations taking place, and to use that as evidence now. What can be wrong with that? What is the breach of a person's right to have an illegal cell phone? And any conversation that this is a breach of legal professional privilege also is taking the country down a rabbit hole, because it's not. Every self-respecting, law-abiding attorney at law would meet with their client, who is an incarcerated prisoner, at the prison, in the room so assigned? Is it that they are advocating for lawyers to have illegal conversations with clients who are incarcerated? Is that what we're hearing from the opposition? It certainly cannot be that. But I've heard it. I've heard the leader of the opposition herself say that this will lead to a breach of the right for lawyers to talk to their clients who are incarcerated. Your client is incarcerated, meaning in jail, and your client is using a contraband cell phone, meaning an illegal cell phone, and that is what the opposition wants to protect, that level of criminality. They want to continue to allow prisoners to have cell phones and to talk freely without knowing that if their conversation is intercepted, engaging in criminal activity, they can be prosecuted and that conversation can be used for evidence. Is that what we're hearing here today? Madam Speaker, this act provides all of the necessary safeguards governing lawful intercept. All. And the suggestion by the member for Oropouche is another rabbit hole chase to only put it for murder or shooting and wounding. I couldn't believe that proposition. So in other words, what it is again an acceptance by the opposition that certain types of criminal activity are okay. For this PNM government, no type of criminal activity is okay. And we condone all criminal activity, and we condone the use of any cell phone, tablet, device, etc. by any person who's incarcerated to call any shots, to call any criminal conduct and criminal activity to continue their criminal empires on the outside, regardless of what it is. We condone all of it. So to hear the shocking proposition that, well, look, try and only use it as evidence if they're going to kill you or if they're going to shoot at you, as opposed to continuing to conduct their criminal empire, be it extortion, be it engaged in narcotics. That is what the opposition is saying to the population. Madam Speaker, we must always protect both the individuals and our national security interests. And these amendments achieve that balance, allowing authorized officers to do their jobs via intercepting, but also protecting the rights of law-abiding citizens. I heard some conversation about who are the authorized officers. Yes, under the Interception of Communication Act, IOCA, the Commissioner of Police, the Chief of Defense Staff, and the Director of the SSA are the only three officers in law who can call for intercept. And the Chief of Defense Staff doesn't do it for the obvious reasons. The Defense Force is not involved in law enforcement. The Commissioner of Police, including our current Commissioner of Policing, and he's doing a great job, asks the Director of SSA to conduct intercept of two types, evidential and other types. And the Director of SSA does it as well. And this is how it has been from time immemorial. There is no breach taking place. The suggestion by the member for Oropouche East to be suggesting that he is the victim of intercept, and it's quite interesting. I don't know where that came from. I think what he was referring to is persons saw him in the Hyatt paying the bill for criminal elements. That's not intercept. That's a first-hand visual. Then to be crying victim about intercept, and there has been no order that I am aware of asking for any intercept there. So these continuous fear-mongering tactics are rejected by us. Just to touch on a few other issues. Why there are so many intercepts? Let the public understand that intercepts are only allowed for specific periods of time, usually under 30 days. So if you're running a criminal investigation on someone, it takes time to build the evidence. It takes time to pick up what you need to pick up on intercept. So it continues to rotate. And every time a new warrant is issued, or every time you go for a new intercept after 30 days, that's an additional. It does not mean that millions or hundreds of thousands of people are being listened to. That's impossible in the current climate. I dealt with the stored data, stored communication. This is to allow when phones are picked up, and these smartphone devices that we have now, you can forensically lift for evidential purposes what is on it. And I knew, and this is where the conflict comes in, because there's a suggestion and then also the reference to civil litigation. The member for Oropouche East should have declared a conflict in this debate. Because you see, there is civil litigation grounded in corruption where he is a defendant. And in that litigation, grounded in corruption, the member for Oropouche East is accused of an exchange of telephone texts. That wasn't via intercept. That was via forensic. What? I am stating pure fact.
I stand on 48.6.
Overrule.
Thank you. I understand the nervousness. Sorry.
Why mask standing order 53 still applies in terms for members who are not speaking?
Thank you very much, Madam Speaker. It is a record. It is a court record. There are court proceedings going on, grounded in corruption, cartel behavior is the accusation. The member for Oropouche East is a defendant in those matters.
Judith Way.
Member?
I will say no more.
Yes,
I say no more on
I was
it.
just about to stand and warn you.
Thank you very much, Madam Speaker. I know the truth hurts. This is not conjecture. This is not throwing this out there, hoping for this and hoping for that result. It's all fact. So, of course, Madam Speaker, of course, the fear-mongering continues. Of course, the obfuscation continues. That is the United National Congress way. But in the short time that I have, and in wrapping it up, what I would like to say is this legislation is necessary. This is an important tool for law enforcement to continue the fight against criminality, persons with illegal cell phones, illegal devices, contraband cell phones, contraband devices within the prison system. And it is interesting to hear the arguments that this should not be permitted. This is to take the fight against the gangs, the persons who are in prison using the phones. This is to allow us the opportunities. Families and lawyers will still have the legal opportunity to speak with persons incarcerated. Thank you very much, Madam Speaker.
Member for Oropouche West.
Thank you, Madam Speaker, for this opportunity to join in this debate, the Interception of Communications Amendment Bill 2020. Madam Speaker, before I proceed to deal with the substantive issues in this bill, which are many, I would like to congratulate the member for Oropouche East for giving such a scorching contribution here this afternoon. It was par excellence. Madam Speaker, when we listen to both the Honorable Attorney General and the Minister of National Security, you think that this bill is really the panacea to fight crime and criminality. You think this bill is really for intercepting calls made in prison by prisoners to call shots outside, as the Minister of National Security said. But what is the real intent of this bill? If prisoners know that their calls are being intercepted, would they say what they want to say, Madam Speaker? If they know their calls are being intercepted, wouldn't they be on a frolic of their own and allow the state to go on a fishing expedition? Because they will send them out, and it means that you are gathering wrong intelligence. So this bill really is not about prisoners and what happens in an amalgamated van, Madam Speaker. There is another intent in this bill. I listened to the Honorable Attorney General, and he spoke about triangulation. Triangulation, the Honorable Member said, is that it's traffic data, and you could store that data, you could pinpoint where that person made that call from, whose phone, the duration of the call, whether a SIM card was changed and so. And there's a GPS locator where you will find that person who had made that call and to whom. I want to ask the Honorable Attorney General that he also said triangulation was used in Gulfview when 3:30 a.m. in the morning,
You had police officers jumping from roof to roof, 6 houses in Gulfview, tormenting and terrorizing law-abiding citizens. Is that the triangulation you have used? And what was the justification? The police officers were in hot pursuit of someone who had a commission of an offense. Madam Speaker, we are talking about 3:30 a.m. in the morning. Dog, rat, horse, everybody asleep. But these police officers, they are jumping from roof to roof, looking for an invisible man because it was alleged that somebody was harboring a kidnapper. Madam Speaker, some of those persons are my neighbors. There was a sick woman, asthmatic attack. You had to have ambulance to take this woman to the hospital. You had some children studying for exams, tormented. What about the triangulation you use in El Socorro, in a Muslim family, broke down doors? I have some photos where you saw the nose of the person who lived in there bleeding. Was that triangulation? Madam Speaker, what this bill is actually doing is that they're trying to make this sovereign state, this democratic state, a police state, and we would not allow it. That is what this bill is about. A sovereign democratic state that allows police to abuse their powers. And we would not have it. Madam Speaker, in another place, the Honorable Attorney General spoke about pepper and heart. This pepper and heart bill, Madam Speaker, the legislation is not applicable in this law. Pepper and heart is when the legislation, the words in the legislation are so ambiguous that you cannot interpret the legislation, then the court will try to interpret the statutory, have the statutory interpretation of it. Madam Speaker, when you read through this bill, clause by clause, you would see the gradual infringement upon the constitutional rights of people in this country. Whether it's Section 4, the rights of privacy, the right to a fair hearing, and if this law were to pass here today, Madam Speaker, it would be struck down as being unconstitutional. Whether it will be struck down by Section 13, which shows whether it is justiciable, or whether it is struck down by Section 1, showing it is a sovereign democratic state. It will be struck down. Madam Speaker, we are speaking about stored data, but there's an issue about chain of custody with stored data. Because we have had many instances, Madam Speaker, when you go before the court, especially criminal court, and you ask, when the judge asks for the exhibits, what do you have? Sometimes you have, take for example, a murder. You may have a bullet that is presented. And when you check the grooves and the striations in that ejected bullet from a particular gun, it does not match up to the bullet that was presented as the exhibit in the court. Madam Speaker, I am asking this chain of custody, who will ensure that the data, the communication is not manipulated? We have had instances where blood samples were removed from refrigerator, so the DNA analysis could not be conducted. We have had a case where the shirt from the person who shot or ejected the bullet, when you did the microscopy, Madam Speaker, the gunpowder in the clothes did not match the shirt that was presented as exhibit. So I need to know who is watching over this data and this communication. Madam Speaker, when we look at the real intent of this bill, and as I said before, if a prisoner if he knows that his cell is being manipulated or intercepted, and if you know it is contraband, and if the Commissioner of Prisons knows that phones ought not to be in a prison, why does the Commissioner of Prisons, together with prison officers, he will instruct his prison officers to sweep the prisons and retrieve those cells? But this is not happening. This bill encourages the prisoner, use your cell phone, I will intercept your call, and I will help build intelligence. Madam Speaker, we're in the fourth industrial revolution in the world, where ICZs, what you have in robotics, you have quantum mechanics, you have vertical farming, and you are allowing prisoners to help you build intelligence. This is Dolly House intelligence, Madam Speaker. This cannot be intelligence to fight crime. And as I keep reading this bill, Madam Speaker, I am seeing more and more erosion of the constitutional rights of people in this country. And Madam Speaker, I was once a zoology lecturer. And there's a group of organisms called protozoa. One of the unicellular organisms, Madam Speaker, is called amoeba. When it's going to enclose its prey, Madam Speaker, it forms false legs around it, secretes enzymes, and dissolves it. As I read more and more in this bill, I am seeing, Madam Speaker, the tentacles of the state grabbing and retrieving the constitutional rights of the people of this country. Madam Speaker, my friend from Oropouche East spoke about warrants. I would just want to clarify and amplify with respect to warrants, Madam Speaker. Is that in the Parent Act, when we look at Clause 6 of the bill, the Parent Act, Madam Speaker, there were, if data was intercepted, and it was intercepted without a warrant, it meant that that data could not be used as evidence in a court proceeding. And if it could not be used as evidence, it could not be a public record. But that evidence could have been used to procure a warrant. In this bill here, and in fact, Madam Speaker, that data in the Parent Act explicitly prohibited the use of intercepted material without the use of a warrant. What we have here in the amended bill, Madam Speaker, and the amendment is really deceptively dangerous. And this cannot be supported. Because this evidence, this so-called evidence now, Madam Speaker, you could now use it in court proceedings, and you could use it even though it was not intercepted using a warrant. So it means that almost anybody, the person who is intercepting, you could intercept anybody's data and communication without a warrant, and it could be used in court and be used as a public record. This is a very dangerous amendment here, Madam Speaker. In fact, I heard the Honorable Attorney General saying that you could use it if it's in the interest of a justice test. But we have the Karuma case, Madam Speaker, where the court in criminal proceedings, the judge always had the discretion to disallow evidence if the strict rules of admissibility, Madam Speaker, would operate unfairly to the defendant. He already had that. The judge already has that discretion. So I'm not sure where the Honorable Attorney General is going with the interest of justice test. What is important is that we have, at common law, we already had that existed, where the judge had the discretionary powers to admit evidence based on how it was procured. Madam Speaker, when we look at section, or propose 17A, Madam Speaker, it is said, and I will quote, where a court considers it appropriate to determine whether sensitive information has been disclosed, the court shall issue a special measure direction that closed proceedings be utilized. Closed proceedings, Madam Speaker, what is the definition of closed proceedings? I have been going through the bill, and I did not see what is the definition of closed proceedings, and what is it with respect also to full disclosure. Because in normal criminal matters, you may have full disclosure going and taking 3 to 5 years. We're not sure here what is the rule or regulation with respect to full disclosure. When we're talking about full disclosure, Madam Speaker, sometimes you may have the prosecution adduce and make an application to adduce fresh evidence. Once this proceeding is closed, the retained counsel and the accused, they are outside of the precincts of the court. So this accused does not know what is going on. This accused does not know what case he has to answer, and how this could ever be in the interest of a fair trial. How this could be a fair trial, Madam Speaker. In fact, under the criminal procedure rules, right now, a witness or an accused has no right to silence. He has to provide witness statement. In these closed proceedings, you have the accused outside. He does not even know what is being transpiring inside the court. In fact, Madam Speaker, when you have closed proceedings, the accused needs to know what is being submitted, the submission against him. He needs to understand, well, in fact, he has to be sitting in court, and as the evidence unfolds and unveils in court, he has to give further instructions to his retained counsel. But not in this bill. The retained counsel and the accused, they are outside. How can this be right? Madam Speaker, when you're in court and you have your retained counsel, he could see exactly the body language of the witness. And recently I was reading an article that said body language, close to 80% of your conversation is done via body language. So you would know when you are listening and you're cross-examining, because when you're in open court, you have the cross-examination taking place, you have your client there, you have the attorney there, and you will have to cross-examine on some issues, because some issues now will unfold in court. You do not have this opportunity with these closed proceedings. All adversarial trials, Madam Speaker, must have cross-examination. This you don't have with closed proceedings. In fact, the accused may not even have a remedy to bring judicial review. He may not even have a remedy to decide how is it that you got this warrant, the conditions on which you get this warrant. Those are excluded. He cannot even get that opportunity. He's deprived of bringing malicious prosecution for the procurement of a warrant. So this is really tilted towards the state and not the citizen. This bill is really gradually eroding the rights of citizens of this country. And it cannot happen, Madam Speaker. Because when you're doing open court, it's an open, what you call open justice, Madam Speaker. Open hearing is open justice, not closed proceedings. Then they are assigning a special advocate. What is a special advocate? Who is this person? Is this special advocate being paid by the state? And if he is being paid by the state, Well, he has a long time to wait because I'm still waiting 12 years to be paid for the state for some legal services, Madam Speaker. In closed proceedings, Madam Speaker, we have a case here called Al-Rawi and others versus the Security Service. I'm not sure if Port of Spain, St. Anne's, what's his name? Port of Spain, Northeast, the Minister of National Security, he's reacting, so I'm not sure if he's suffering from Delcy syndrome. Madam Speaker, we have a case, Al-Wari and others versus the Security Service and others. Madam Speaker, this case, it has nothing to do with the Honorable Attorney General, Madam Speaker. In this case, if I could seek your leave, Madam Speaker, to just read a few lines. In this case, it says, a closed material procedure involves a departure from the principles of open and natural justice, which are essential features of a common law trial. The judge went on, and he cited the case of R versus Davis, 2008, appeal case 1128. And the House of Lords in Davis said, the right to be confronted by one's accusers is such a fundamental element of the common law right to a fair trial that the court cannot abrogate it in the exercise of its inherent power. This prevents him from being able to see and challenge the evidence and submissions made in the closed hearing. He may never know why his case was decided the way it was. But what we are having here, Madam Speaker, in this amendment, in this bill, which erodes the rights of citizens, you have closed hearing. And then you are signing a special advocate whom you have not retained. You have not retained him. You haven't given him proper instructions. If inside, during the court hearing, Madam Speaker, if evidence unfolds and fresh evidence is adduced. Ready?
Your time is now spent.
Oh, thank you. Thank you, Madam Speaker.
Member for Parliamentary West.
Thank you very much, Madam Speaker. Madam Speaker, I rise to make a very brief intervention into the deliberations before us here today. Let me begin immediately by addressing a few points made by the member for Oropouche East. And I can do so confidently because the Attorney General, as he set out the measures in this amendment to the Interception of Communications Act, Chapter 1508, did a wonderful job in indicating the reason, the observation of the constitutional requirements, because the original bill needed a special majority. And of course, this one, for obvious reasons, it is quite clear that it touches and affects the normal constitutional rights enshrined in our Constitution for the protection of those who are subjected, the citizens of this country. He did an excellent job in identifying all of those things. All was going well until the member for Oropouche East got up. And he had a few things to say, and I think, Madam Speaker, you would permit me to set the public's record straight on some of these issues. Madam Speaker, first of all, the member identified that he was a personal victim of some of this, meaning interception of communication and police attention. Let me stress police. It touches some of what the member for Oropouche West has just said. Nothing in this bill, or in the Parent Act for that matter, gives any power or authority to the Prime Minister, any Minister of Government, the Cabinet. The measures here give power to the institutions of this state, the police, the SSA, and other intelligence gathering operators who are duty-bound under law in some cases to protect the innocent and the law-abiding citizens from the behavior of criminals. It is the police and those agencies who stand between us and the criminals who want to have their way. at our expense. So nothing in these measures, Madam Speaker, gives any additional authority or power to the Prime Minister or the government. So when you hear them saying they want more power, what we are doing here as legislators is presenting the law for the consideration of our friends on the other side. And this law we didn't pull out of a hat. We would have gotten advice, information, requests from the police and from the SSA and from the office of the DPP, that institution of the DPP, independent and astute, who by virtue of practicing in the criminal law and dealing with criminality in this country would have seen and experienced weaknesses in the system, weaknesses in the law, some that we did not contemplate on its original passage, and would have asked the Office of the Attorney General to address some of these measures in order to protect us. And the Minister of National Security asked on diverse occasions during a short 20-minute presentation, what is wrong with that? What is wrong with this law? What is wrong with a law which tries to find out what criminals, sometimes even in jail, are up to carry out their criminal conduct from inside the jail using technology? There was a time when the police in the UK didn't walk around with guns. Today they walk around with automatic weapons because they have to respond to the behavior of criminals. There was a time when we had no Interception of Communications Act because criminals used to talk to each other. Today they use the most modern technologies you can find to communicate. In many jurisdictions in the world, there are specialist police officers and intelligence operators who would learn all the colloquial terms for guns, for drugs, for everything in order to decipher the messages shared between.
Listen, with your friend.
That is an example of interception of communication, Madam Speaker. Well done. Madam Speaker, so that the authorities, the law enforcement agencies, have to stay up to speed with the criminals. The question of stored data arose in these deliberations. When the police stop criminals, find them with guns in the car or about to commit a crime, and they seize guns and money and their vehicle and they seize cell phones too, common sense tells us that those phones are, of course, useful because they're used to communicate. And therefore, the authorities want to know what they were up to. It may be to stop them from coming here to place an explosive device. The Minister of National Security, understanding what he has to deal with, understanding with the issues raised by the police and law enforcement on a daily basis, asks again, rhetorically for me, what is wrong with that? But for my friends on the other side, everything is wrong about it. And you will find in some countries, I saw in a documentary only 2 nights ago at my home, Madam Speaker, the CIA has a system in place where if in your communication, whether email, text, WhatsApp, telephone, if you only mention a slight threat against the President of the United States, they're coming to find you to determine whether it's real, whether you are just a madman, whether it's just a prank, or whether they have to pay special attention to you. That is where we are. What is wrong with that? Except the only people who have a problem with that in my submission are those who have committed crime and don't want it to be detected, those who are committing crime and don't want it to be detected, or those who have a criminal bent, criminogenic tendencies, and are afraid that law enforcement will pick up with them. The member for Orupuchis became very personal. But I recall, as chairman of a certain joint select committee, the commissioner of police told us something about that member. Yes, that's a fact on the parliamentary record. And without saying much more on it, Madam Speaker, when the commissioner spoke, he told us there was a planned meeting between well-known criminals.
Has there been a report?
No.
with respect to that?
This is the proceedings of a... Madam Speaker?
Has there been, has the report on that been laid as yet?
Madam Speaker, I should proceed.
Please.
The report was laid. So let me proceed. Thank you very much, Madam Speaker. And when the police put up their intelligence apparatus to go and pay attention to the meeting between the member for Oropuch East and the criminals from all over this country, the commissioner told us that the member for Oropuch East appeared to have found out.
Proper motive that member for Oropuch East is dealing with criminals.
Just, Madam Speaker, with...
All right. Member for Naparima, we proceed in a particular way like this. Member for Point Appear, that is why I asked if the report was laid. If the report has been laid, he can proceed.
This report was laid, and if I'm wrong, let him take me to the Privileges Committee. Right? The meeting was called off. So apparently, according to the police, the member for, well, other persons involved in the plan found out that they were being put under police observation and aborted the meeting. In other countries, they would have seized all of them on the cell phone, and they would have been able to access the stored data to see what was afoot. And if there's a problem with this law, and he went into the report of the SSA, I, sometimes as a minister of government, and sometimes act as Minister of National Security, I would say if we have a problem, it's because our law enforcement agencies don't fight it and give enough. Because there's a lot that needs to be found out in this country. And if they prosecute nobody, as the member for Oropuch East said, it is to our detriment. And I would like to see them step up their game. They might catch some big, big fish. And that is not necessarily a criticism. I'm just saying we should. I don't know what their problem or what their situation might be. Madam Speaker, let me continue. He also said that for the last 5 years, no police has come to him and asked the member for Oropuch East any question about any crime. Well, the former Attorney General and another one can't say that. What I want to say is that one of the corruption cases we have from the previous 5 years, we rely today on the evidence of a Queen's Counsel coming out of England. That's all I want to say. None of them, and no other Trinidadian might be willing to come forward and to do what that individual has done. But that is another matter that will be addressed in due time. And Madam Speaker, in closing on him, the member for Oropuch East, he told us it might be that the United States have some plan to impose sanctions, spreading false talk and false rumor, which is what they wanted to see. They wrote letters and they tried to impose that on Trinidad and Tobago, but God is a great God. Went further to talk about the Minister of National Security told some lie. I don't know what that is.
Again, I'll ask you.
Thank you very much, Madam Speaker.
No, just 1 minute. I'll ask you to withdraw that.
I withdraw that.
It was withdrawn, yes.
He withdrew it, Madam Speaker. Okay, thank you very much. Well, that itself was an untruth. Madam Speaker, he spoke about the question of the special advocate. The idea of the special advocate, Madam Speaker, is a concept that exists in England and in many other countries. It has come to Trinidad and Tobago because we have some bottlenecks in the criminal justice system, where criminal cases were piling up and people were not getting their day even in the criminal court. And part of the reason for that was because when their matter is called before the judge and jury, the defendant or the accused would say, my lawyer is not here, he is next door, he's in the first criminal court dealing with a murder or another matter at this time. And the Constitution allows you to have an attorney at law of your choice. So if he chooses that attorney, then the court was in a predicament. that has contributed to tremendous delay in the criminal justice system. And that is why the idea of the special advocate came in. Highly trained, specialized in those matters, who would go to the police stations and who would go to court on behalf of the accused if the lawyer he wanted, the advocate he wanted, is for those reasons unavailable. A noble and clean idea. What is wrong with that? And talking about intercepting communications between them. That is for sensitive information as the law defines, one. And two, the truth is, some lawyers are criminals. I know two in Trinidad and Tobago today, without calling a name, who are before the criminal court for criminal conduct. And one was known to be involved in matters, I ain't calling no name, involving a dead prisoner on the one hand and a cut and paste operation that they call in Trinidad and Tobago. If you could intercept that, it would help. And these measures are designed to give the police and the SSA and law enforcement the power to get behind the tricks and the curbs and the schemes and the plots of those who want to hurt us in Trinidad and Tobago for money's sake or for political power's sake. What is wrong with that? This act, this amendment bill, in Clause 4, treating with the admissibility of evidence in the Parent Act in Sections 6, 8, 11, 17, and 19, Madam Speaker. Those provisions in the Parent Act deals with criminal proceedings, admissibility of evidence in criminal proceedings, allowing the court to determine whether it will accept such evidence or not. Section 4A, which we are now putting in the amendment, a new Section 4A, treats with criminal proceedings more generally, proceedings under the Proceeds of Crime Act, because if you get involved in a criminal conspiracy with prisoners to steal money from the state with false civil claims, and this act will empower the police to use intercepted evidence, nothing is wrong with that. It says as well in C, proceedings under the Extradition, Commonwealth, and Foreign Territories Act. And most of all in D and C, proceedings under the Anti-Terrorism Act and proceedings under the Civil Asset Recovery, Management, and Unexplained Wealth, a piece of legislation that we passed here a few months ago. Those two, while admittedly having a significant civil component, does have pseudo-criminal elements in there for the seizure of property and the proceeds of crime. So the member for Oropouche East, wet behind the ear, if I may be permitted that metaphor, insofar as the law is concerned, missed that very salient point. And therefore, this amendment allows the material that is garnered in the conduct of the police's investigation to be used in those ways. What is wrong with that? And we are so strict here. Every time we come to pass legislation, the opposition makes it a point to demand the most strict interpretations, the most restrictive provisions, almost to tie up the hands of the police. When we should be, I'm not saying we should allow here for police to go unchecked, because we have laws and they have to operate in accordance with the laws. And those who do not will be prosecuted in accordance with those laws. But more and more, we should be trying to assist the police in dealing with crime. Especially my friends on the other side who take every opportunity to complain about crime. Hypocritically, Madam Speaker, traffic data in this law talks about, in relation to communications, mean any data, purporting to identify any person, apparatus, or location. The Attorney General explained that well. Let me give you an example. A major crime occurred in the north of this country. A major crime in which I think 2 or 3 people were murdered. And the criminals flee from the scene. And the authorities, because the way the structure is set up, were able to trace their movements, and rightly so, until they went under the radar. And we know why. They explained that when they briefed the public. And, Madam Speaker, I don't want to get into some details, but these technologies and these laws are very, very important because the criminals are no fools. And in some cases, they are properly well advised by some criminal lawyers, describing the practice and sometimes describing the individuals. Say so without apology. And I have already shared with you, Madam Speaker, evidence of at least 2. And if my friend, the member for Point of View, provokes me this afternoon, I'll call the name. So, Madam Speaker, I know you all want me to call the name. I know. Madam Speaker, based on the experience of law enforcement, Section 7 is amended. We introduce a new 6A. Well, 6A1 says, the Commissioner of Prisons shall cause all prisoners and members of staff of the prison to be informed that any communication transmitted to or from any device which is in the prison or in a vehicle used to transport prisoners may be intercepted. And this is real. Phones get into the prison. Money gets into the prison and get out too. They have prisoners today using technology in the prison and coming out of jail as not millionaires, but with plenty money. Extorting people on the outside. Have their poor mother and have their poor aunt putting 200, 300 on phone card and it is sold, the use of the phone inside the jail. Fellas coming out rich with property. This is real. Carrying on their criminal enterprise from in the jail. But here we have a provision where the commissioner is obliged under this law to notify all prisoners and to notify the public that this is an area that we use, that if you communicate and it is intercepted, we will be able to use it in evidence. Under the current law, you have 2 types of information they get. One that is warranted and the other that is not. Section 7 warranted, Section 8, or Section 8 warranted, Section 7 not. Okay, Madam Speaker? And how the thing works, if someone is up, as they call it in the law enforcement, if the law, the Interception of Communications law, permits the Commissioner of Police or the Director of the SSA or the Chief of Defense Staff to put you up, in other words, to have you on observation under law, and in all cases a judge, nothing in these amendments allows anything to happen without the court being involved. Those are some of the strictures we have. Yes. It is a pity, Madam Speaker, but I thank you.
Member for Naparima.
Thank you very much, Madam Speaker. Today, we are here to discuss the Interception of Communication Amendment Bill 2020, and I would like to congratulate my 2 colleagues for raising the concerns in the courts of law and in the constitutional infringements by a government that is bent on becoming a creeping dictatorship. Madam Speaker, I speak.
Thank you. Can you please retract?
I retract.
Thank you.
I retract. Madam Speaker, I am concerned about democracy because in 2015, an email which I sent to colleagues on my campaign was read out on a PNM platform by no less a person than the MP for Aruka Maloney. Madam Speaker, that is a fact. Madam Speaker, I am concerned because my name has been called, but by Cambridge Analytica, falsely claimed, falsely linked with Cambridge Analytica. I had to go to the media and said, I know nothing about any pink-haired individual.
And I'll give you a little liberty.
Yes. Yes.
Quickly, because remember, you have a
Yes,
little
I'll do
time.
it quickly, Madam Speaker.
Right.
Because Cambridge Analytica deals with the interception of information. And that was based on a Netflix video, which the reputed Economist magazine said is a misinformed video about misinformation. And I'm only making that point to state that the depths to which my colleagues opposite will go to paint a negative picture based on false information is difficult to comprehend. Madam Speaker, we heard from the Minister of National Security the fact that basically this bill deals with the interception of communication between prisoners and persons outside. We are told that hits are called from prisons. Well, Madam Speaker, if you want to solve that problem, stop the phones going into prison. Simple. Or jam the signals coming out from phones. Let me point them, my friends opposite, to an article published by Mike Haynes and Nick Jordan. And it says, How to Cure Prisons Contraband Mobile Phone Epidemic. It's dated 16 July 2019. And he says that prison officials the world over know that better than anyone that prisoners will go to any lengths to obtain contraband cell phones. And they speak about the solution. And they say the solution must be a multi-layered approach to security. Nowhere do they mention anything about passing any legislation to solve basically what is the problem with phones in our prison services. They talk about tactics, walk through metal detectors and X-ray units at all points of entry. They talk about portable detection equipment, drone detectors, shakedowns and more. Tactical approaches to solving that problem. Not a legislative approach to solving it. They talk about technologies. They say these should be deployed at all entry points. They suggest what they call a portable ferromagnetic detection system, FDMS, which uses passive sensors that detect a magnetic signature down to a millionth of the Earth's magnetic field. They say staff can use these alongside X-rays equipment at entry points to screen people, then pick up the unit and use it throughout the facility to conduct full body searches. And hear it. And this is why we're always behind. And I suspect they do not read, they do not research, and they do not see what other countries are doing. Madam Speaker, they said this technology has been deployed in 46 countries across the globe, including all New Zealand and UK prisons, all, including state prisons, all 54 state prisons in New York, all 24 state prisons in Maryland, and it's also used in California and in Indonesia. So you bring us here in Parliament to solve a problem which could be solved by the existing technology and is used all over the world. Madam Speaker, this bill was introduced in the Senate on February 4th and passed in the other place with amendments on the 3rd of March. Just 1 month. And the questions need to be asked, why did government rush to push this piece of legislation, which in our view has serious shortcomings and avenues for potential misuse by officials? Madam Speaker, when you read the Senate Hansard from March the 3rd, during the committee stage. Madam Speaker, the Attorney General stated on page 173, and I quote, in the rush, in terms of the circulated amendments, in the rush to prepare this, Mr. Chairman, I want to apologize. We really should have put all the new clauses at the end. So I am a bit buried, and I apologize for that. But I only got the chance to look at this on the floor. The AG himself admitted that he did not have enough time to look at the circulated amendments before that sitting. So here are we, 1 month, 2 months, or 3 months before the end of that government and the election of a United National Congress government. We have rushed, ill-conceived, not well thought out legislation. Madam Speaker, it will be left to us to implement this legislation. And we are saying today, well, it wouldn't pass. It would not pass because we are committed. Our leader has told us that we will not be party, we will not be co-opted to poorly drafted legislation. That is a fact, and we say that without fear, and we will not be coerced by anyone to do what in our conscience and what in our best frame of mind tells us is not in the interest of the people of Trinidad and Tobago. And we make no apologies for that. In the fight against crime, we cannot ignore the realities of persons intercepting communications and information under the guise of looking for illegal activities. Madam Speaker, given an impending general elections, I must say that the timing of this is
okay. So, Member for Naparima, I have noticed your heavy reliance on your notes. I think by now, you've just spoken about the 4+ years. By now, I think you can be less wedded to your notes. It is a debate.
Yes, Madam.
Thank
yes,
you.
Madam Speaker. The question is, why are we here today? Will this bill reduce crime? And I don't have to look in notes to tell you that the murder rate today is at 193. And we are heading for the 3rd consecutive year of 500 murders. Will this bill help us reduce the murder rate? Will it deal with the underlying, I don't have to read, will it deal with the underlying social issues that are the main contributors to crime in this country? Poverty, lack of jobs, a governance that does not deliver good governance and safety to the people of Trinidad and Tobago.
Rise on Standing Order 48-1.
Okay, so, member, I'll allow you to continue, but please remember what we're debating here.
Yes,
yes.
We are discussing the bill. The bill. Yes, Madam Speaker. Are there less costly alternatives than coming to this Parliament with this bill? Can this bill be operationalized? In terms of why am I here?
Irrelevant.
Okay.
Okay, so please.
Okay. Going back, what is this legislation really about? Is it really about electronic surveillance and data capture? And going back to my question on whether existing legislation can be used instead of introducing new amendments in the law.
10 again, please, Madam Speaker.
Madam Speaker.
Please proceed. You have reminded me that you don't need your notes. So please
yes,
proceed.
Madam Speaker, but I'm looking at you.
Please
yes.
proceed.
I'll proceed. The Attorney General stated in the Senate on March the 3rd, and I have to quote now, so I'll be reading now. Mr. Chairman, at clause 15, the amendments are circulated as intended for us to capture the fact that there may be interceptions permitted in other laws. So, for instance, at present, we have the Administration of Justice Indictable Proceedings Act. At present, we have the Indictable Offences Preliminary Inquiry. At present, we have the Proceeds of Crime Act. Those are 3 known laws at this point. And the question I'm asking, if these laws are not effective at this stage, what assurance we have that in the short time frame we have, that we will be able to operationalize this law in time for it to have a measurable impact on the reduction of crime. We have issues, Madam Speaker, with this, one of which fundamentally is parliamentary oversight. Section 24 of the Parent Act clearly states that, and I quote, the minister shall within 3 months after the end of each year, in relation to the operation of the Act, in the immediately preceding year, prepare a report. End of quote. The clause further details what information must exist in the report. And a copy must be laid before both houses promptly after its completion.
Honestly, 48.1, the members refer to a clause that is not in the bill. There is no clause to that effect in the bill.
So, member for Naparima, please proceed with relevance to this bill.
Madam Speaker.
Please proceed with relevance.
Yes, Madam Speaker, I'm speaking about the bill and what the bill calls for in Section 24 of the Parent Act. It calls for bills to be laid in Parliament. And I'm stating...
Not debating
yes,
the Parent
Madam
Act.
Speaker.
So if there is an amendment to that particular section, it may be that you may be raising that particular section to show how the amendment affects it. But if not, you can't go back to the Parent Act.
Madam Speaker, I am saying...
I have ruled and...
You have ruled, but this bill has to be laid in Parliament 3 months after the year in which it operates.
On Standing Order 48.1, this bill, there's nothing like that in the bill, Madam Speaker, respectfully. Absolutely nothing, remember?
Madam Speaker, this was raised in the Senate.
Well, that's precisely the point. It wasn't raised here.
Yes.
It wasn't raised here.
Yes.
And again, I say to you, if it is not a clause that is impacted by this amendment, I'm not going to allow you.
Okay.
So please continue within that context of the guidance I've given you, or else I'd ask you to take
Okay,
it.
I'll go on, Madam Speaker.
Thank you.
The other question we have is, given that this bill and act as a whole, and this act on a whole, affects the rights of individuals, and there are significant privacy concerns, we are saying, why, as was said in the Senate, why could there not be consideration be given to a sunset clause in this bill? The Minister of National Security indicated that because the Act was operational since 2010 without a sunset clause, then it does not need one now. He is on record as saying so. And the question we ask, Madam Speaker, is if there were not a sunset clause, we are in the business of improving legislation. And if we feel that parliamentary oversight will be better developed by a sunset clause so that we could come at the end of a period, analyze whether the act has worked, whether it has reduced crime, whether there are shortcomings, we feel that it would be better served if there is a sunset clause. Madam Speaker, the authorized officers under this act are the Director of the SSA, the Chief of Defense Staff, and the Commissioner of Police. However, Madam Speaker, they report to the Minister of National Security. And the Minister stated on Hansard, February 11, 2020, at page 76, the Minister said so. I quote, "There are 3 authorized officers, the Commissioner of Police, the Chief of Defense Staff, and the Director of the SSA. There is nobody else, pursuant to the legislation of Trinidad and Tobago, that can legally intercept. Those are the people that we have entrusted to carry out their job and their duty. And there is only one person, and this is the Minister talking, there is only one person that they report to, the Minister of National Security." He goes on to say, "So every single time whether it is a warranted intercept or whether it's an intercept for intelligence, the Minister of National Security, within a number of hours, and then he says days at maximum, is provided with a report that an intercept has been started. And the minister further stated that if he finds something that is supposedly wrong with the intercept, he calls in. He says, and I quote, "If I find something strange..."
Member,
yes.
Remember this is a debate.
Yes, madam.
While it might be relevant, I can't allow you to read long extracts without tying it into a debate. So right now, all I'm hearing are these long extracts from the Minister of National Security in the other place, but you haven't tied it in. Please, please. I think you should take your seat. Next.
All right.
Member for San Fernando East.
Madam Speaker, thank you for the opportunity, Madam Speaker, to contribute on this bill and to place some brief comments on the record, this Interception of Communications Amendment Bill 2020. Madam Speaker, let me just start with something the member for Naparima said just a short while ago. The member for Naparima wrongly alluded to a situation where the minister shall be informed by those seeking to intercept and record communications. But, Madam Speaker, let me just correct that on the record.
Member for Naparima, please have a seat. I'm speaking. Member for Naparima, please have a seat. Member for Naparima, I ask you to leave the chamber for the rest of today. And quietly. Please continue, Member for San Fernando.
Thank you, Madam Speaker. And Madam Speaker, even though it ought not to be said, I take great umbrage to the behavior for the member for Naparima. Madam Speaker, it is unparliamentary. Madam Speaker, contrary to what the member for Naparima said, that the minister shall be informed, and creating the impression that one should do interception or one should do recording of communications, that somehow the minister is informed of this. Madam Speaker, may I please correct that on the record and direct you to Section 22 of the Parent Act, where it says, the minister shall be informed, A, of an interception under Section 2B within 96 hours of the commencement of the interception, B, of an application under Section 8 by the authorized officer who has made the application as soon as is practicable after the making of the application, and C, of an application under Section 11 by the authorized officer who has made the application within 48 hours. But, Madam Speaker, the Minister of National Security is not given information as to who is the person and the nature of the interception and the recording at all whatsoever. That is a matter for law enforcement officers. Madam Speaker, the member for Naparima, when he started, indicated that somehow his communication was intercepted when an email was revealed just before the general elections. But, Madam Speaker, that does not mean that his communications was intercepted by anyone on this side. It just means that some of his colleagues just did not like him and wanted to embarrass him and reveal his communications in the open. Madam Speaker, the member for Naparima was spinning a wheel in the middle of, Port of Spain. It was just further embarrassment to the member for Naparima. And Madam Speaker, I cannot believe that the member for Naparima was trying to suggest in this House that somehow the People's National Movement had anything to do with the making of the Netflix documentary, The Great Hack. I cannot believe that the member for Naparima was suggesting that we created the Netflix and we had something to do with the creators of The Great Hack, suggesting that members of the UNC was
Madam
involved.
Speaker, I stand 48-1. I'm totally confused now.
Please proceed.
Madam Speaker, I'm just responding to what Naparima said. I'm sorry that you are confused.
Please proceed.
Thank you very much, Madam Speaker. Madam Speaker, it was suggested in that documentary that Cambridge Analytica participated with the UNC to manipulate the citizens of Trinidad and Tobago. Madam Speaker, the member for Naparima also spoke about technology used all across the world and suggested a lot of alternatives of technology that can be used to arrest criminals and criminality. But Madam Speaker, what is wrong with this particular technology and mechanisms that are used all over the world? That is what the Attorney General, that is what this government is suggesting that be used. He suggested, Madam Speaker, that it would not pass, but could not say what was wrong with this bill in principle. What was wrong? Madam Speaker, he could not indicate during his contribution what he would do differently to arrest criminals and criminality that is the scourge of Trinidad and Tobago today. There is no denying, Madam Speaker, that this is a tool, this interception of communication is a tool, an incredibly important tool that is used across the world in arresting criminality. And we're using it here in Trinidad and Tobago. I listened to the MP for Orapooch East, the member for Orapooch East. And Madam Speaker, he may or may not have a conflict, but the minister did not use his time during his contribution to speak to the merits or the demerits of the bill before us. He used his time to throw picong and to advance his own personal political interests. And Madam Speaker, the member for Orapooch West, I heard the member speak, and the member tried to distract us with technicality, protozoa and amoeba. Madam Speaker, it has nothing to do with that. They're trying to distract us with technicalities and things that have nothing to do with the objects of this piece of legislation. So, Madam Speaker, let us get back to the bill and the object of this piece of legislation. It is axiomatic, Madam Speaker, it is well accepted that communication is done freely from behind the prison walls. Everybody in Trinidad and Tobago knows it. You see them, you see prisoners on social media. They use Facebook, Madam Speaker, and some members of this in this very same house may have received communication from prisoners behind the prison walls. We know it. It happens. We understand it. Members in this house, some of us, we have some very challenged communities, and we know some of the main operators in the criminal world. We know how they operate because people come to our constituency offices and they speak of fear. They speak of fear for reprisals. Some of them live in the plannings, the multi-story HDC communities, and they speak of it. And what you commonly hear is the fear of this so-called long hand from behind the prison walls. Madam Speaker, witnesses are fearful for their lives in coming forward to give evidence to arrest this thing we call criminality, for fear of someone calling a shot from behind the prison walls. But Madam Speaker, this is not just about murder. We talk about murder. We talk about where certain prisoners, some of them on remand, desperate as they are to escape to be released from prison, try to interfere with witnesses, try to eliminate the evidence against them in the courts. But, Madam Speaker, some prisoners, as the member for Laventille West alluded to, actually conduct their criminal enterprises from behind the prison walls. And in that regard, Madam Speaker, I stand here to fully support the proposed sections 6A and 6B, which speaks to the warning by the Commissioner of Prisons that prisoners and members of staff, they will be informed that their communications may be intercepted. And in section B, communications in a prison or prison vehicle they will be warned as well that it may be recorded. Madam Speaker, I am in full support of that. And I'm in full support of that because of an experience I had at the Ministry of Housing. And with your permission, Madam Speaker, I just share that experience, because it's not just about murder. Madam Speaker, at the Ministry of Housing, there's a program called the Squatter Regularization Program. It's a PSIP program. And this problem, as I said, is not just about murder, firearms, and violent crime. This problem also affects the state's ability to conduct its business. While there, Madam Speaker, the Squatter Regularization Program, it is about going into squatter communities.
Madam Speaker, I stand on 48.1.
Please proceed, Member for San Fernando.
Thank you very much, Madam Speaker. The Squatter Regularization Program is about going into squatting communities and doing infrastructural upgrades to ensure that these land developments are brought up to a level, up to a certain standard. Madam Speaker, while there was a project in Lapai, Caroni, and a tender was done, a tender was awarded, a company mobilized on site to conduct some drainage works, some water works. So the contractor mobilized, put their equipment on site, their backhoe, their excavator, etc. And one night, they got a call, the backhoe was on fire. Backhoe was completely burned down. And the very next day, Madam Speaker, the contractor received a call from a notorious gang leader from behind the prison walls. A notorious gang leader. And Madam Speaker, that gang leader knew the contractor's name, family's name, the contractor's address, obviously the contractor's phone number, and they knew every aspect of that contract. And the contractor knew that there was a security component in the contract, and the contractor demanded the payment of that security component to his associates on the outside. These amendments, Madam Speaker, would help in that situation. The gang leader also started to call senior members of the Land Settlement Agency as well, demanding further information. Now, reports were made to the police. The police in that situation threw their hands up in the air. They could not do anything at that point in time. They simply could not. The contractor, Madam Speaker, sadly ended up paying the money to the criminal enterprise. The senior officials at the company, they had an extremely strong suspicion about a particular clerk of works. And his contract was not renewed, and all such calls stopped, and interference with contractors on these types of jobs stopped. Madam Speaker, there was considerable property damage and considerable fear. The job was slowed down considerably, and it seriously interfered and impacted the state's ability to conduct its public sector investment program, and seriously impacted that community's ability to finally get proper drainage and proper waterworks in their community. So, Madam Speaker, I have heard the Attorney General and I've heard the Minister of National Security, and I too understand the safeguards, and I am comfortable with the safeguards that are placed in this bill. But, Madam Speaker, it definitely is a scourge. The ability of prisoners to communicate with the outside world, to interfere with justice, interfere with witnesses, and, Madam Speaker, interfere with the state's ability to conduct its affairs. So, Madam Speaker, I fully support this. On behalf of the people of San Fernando East, I fully support the measures in this amendment bill, and I thank you for the opportunity to contribute. Thank you.
Honorable members, it's 4:31. I believe there's been agreement that there'll be tea and still comply with the COVID time restrictions, so that we will break now. We'll return at 5 p.m.